on 29 February. But till date, the order is not in up to date.
Which one? Item? Bail matter.
Bail matter.
Which item? Number you just missed.
657 or 24 on 29th. Yesterday, I have also given that number to.
What is that? Where is that? Why is not happening?
Bail matter is not uploaded.
Not uploaded. That's what I say. Every day I do it. Why it is not uploaded? Who is taking decision? Tell me. Bail matter same day it has to be done.
My lord, pardon to mention.
Just check it up. Sorry, it might have missed.
No, because
at my office level or somewhere. Who will check it up?
Advocate and the client and also the land district judge, they have first.
We'll check it up.
Right.
That
My
may
lord-
be a human error. Let us see.
Yes.
My lord, pardon to mention, my lord. Item 3 permitted to
Withdraw.
pardon to mention item 68, my lord. Next week, my lord.
No,
Because
it is the fresh matter or after?
first matter.
Sure.
My lord was directed to produce the charge sheet, but the petition
68. Fresh matter then.
next week.
Pardon to my lord. You are also this
You
CLMC.
just ask for adjournment.
First one.
When the date will be given, we will decide. Okay. Okay.
Your lordship,
68.
item, my lord, item 4. Item 4.
Hmm.
Item 4 on behalf of Mr. Sharma, kindly adjourn it to 1 week.
No, this is after notice or fresh matter? Fresh matter.
Fresh matter.
Urgent.
Your lordship,
Another matter, item 90.
Huh?
Another matter, item 90. 138 NI matter, the compromise is going to be to 90.
90. It is also fresh matter.
No, 138 NI act matter. The compromise is going on.
Pardon to mention, sir, the urgent matter fixed to 9/11/23 were not listed yet.
Give the memo.
Pardon to mention, rejection of 311 petition. Matter will be infructuous case is posted to 7. Accused statement by sorry, you allow 311. Whatever your lordship may pass over.
your lordship, CLMC was filed 14 November 2023, but it has not been
आपको
listed.
memo दियो तो देखिए.
7 तारीख को डेट अच्छी तरह कोर्ट रे.
My lord, one case admission CRLMC 671 of 2024. My lord, the petitioner is challenging the order of rejection. My lord, rejected by the Lornet Code Bill 142A
You
petition.
give the memo.
Lordship,
See, there is no
already-
priority. There is no
Lordship, already
priority.
given.
We will just see.
Pardon to mention, my lord.
The petitioner is the brother of the informant.
नहीं,
Pardon to mention,
what is
my
the
lord.
urgency?
Urgency is now petitioner victim has already been married.
So marriage is not
No,
urgent.
marriage ତାଙ୍କ husband ଖାଲି ଜାଣିବ ସେ ଯାଇଛି ବୋଲି ସେ ଚାହୁଁଛି proceeding ଟା ସେ ନିଜେ ଗୋଟେ CRL ଫାଇଲ୍ କରିଛି.
We just take it. Just we'll see
ଫାଇଲ୍ କରିଛି.
how we can adjust it.
Pardon to make a mention, my lord.
Yes.
My lord, item number 5, I seek for an adjournment.
Fresh matter?
Yes, my lord.
You are not sure.
No, my lord.
Wait then. Wait. I will be.
Pardon to
called.
mention.
Your lordship, item number 65, I pray for my adjournment, your lordship. It's a fresh matter.
Fresh matter.
Yes, your lordship.
I believe you. I adjourn. Thereafter, somebody comes and says that it was
Lordship.
taken behind my back. That's the old difficulty.
We are the
Fresh one. Fresh and
obligement.
Lord, pardon to mention.
My lord. My lord, one BLAPL number 1754. Fresh. It's not yet to be listed. And my lord, he has a small child of 6 years old. May kindly be listed, my lord.
What do you want from that?
His exam is going on, my lord.
Custody.
Yes,
Custody
Custody.
in 482. What will I do? Custody court is something.
may kindly
somewhere
be listed early, my lord.
Give them
Yes.
Pardon to mention, my lord. Pardon to mention.
any mentioning. Yes.
Yes, my lord, there is a tagged matter. There is a tagged matter. Your lordship may kindly see that when the co-accused Upendra Pangi was released on bail on PLAPL 557/24. And my bail application is 14,369/23. It's a tagged matter, my lord.
Tag the co-accused got the bail.
Yes, my lord. Your lordship has directed him to be released on bail 27/2/24.
I might have committed some mistake. Why do
No,
you
my lord,
commit
no,
murder?
not at all. Not at all. You can.
Take
So
the
it
number.
may-
Take the number, Mr.
Sir.
Murthy. Oh, give the number.
14369 14369.
24.
23, my lord.
23.
Yes,
Huh?
yes.
Okay, this is not an assignment belongs to this court.
But your lordship has released him with the co-accused on bail, my lord.
That's right, but it has to be listed there and that court has to send it to my court.
My lord, it is actually your lordship.
That's the procedure what to do. You mention in the concerned court
Yeah, my lord.
and get it listed because eventually it has to come to this court because the co-accused bail has been granted by this court.
That's why I'm actually mentioning it.
But I can't ask for listing. You have to go to that court only.
Okay, my lord. Okay, I will.
I beg pardon, my lord.
Yes, Mr.
I beg pardon, my lord. My lord,
Yes, tell me.
item 7, my lord, fresh matter.
Yes.
Some document is required to be filed before your lordship. So I prayed the long date,
Okay. Press matter. No
my
problem.
lord. Item 7. Oblige your lordship.
Mr. Mansingh. The crime and yes. Yes. I don't know. There is no indication. If the least, is there any indication? Taken up for two.
Item 17.
Yes. Yes, 17. 1717. List place ko na di.
There is an indication that the bail matters will be taken up first.
Sorry,
Because before lunch, if the bail matters are taken up, at least they can type it and upload it. That's the idea.
Sorry, my lord, I am
So-
not. 17 though.
70. Yes, tell me.
Your lordship, the offences are alleged on 307 and other offences. Other offences, 354, 294. CD is not there, get the CD. Grievous injury is there.
307?
Yes, 307. 307. Assaulted by beer bottle and wooden stick. Beer bottle को तो अच्छी की FIR की थी, beer bottle ना आया क्या? CD ऐसे देखा कौन?
FIR bottle राखी हो थोड़ी.
नहीं।
FIR लिखा ही थी beer.
आया?
FIR लिखा ही थी beer bottle.
हाँ से लगा beer bottle है, मदो पी के ऐसे ले थाने. That is the finding.
Anyway, CD
Yes,
more.
yes, yes.
CD more. CD more.
CDS हो.
Next week, हाँ.
Next week also.
Item 18.
Yes. Yes.
Item 18.
18 password.
19.
May I please, my lord?
Yes.
My lord, this is a case, my lord, in which this petitioner earlier was on bail by the order of this honor annexed to my lord. Then that's my lord Justice Sierdas granted bail.
Yes, my
to the
lord,
petitioner.
Belgium matter. Belgium matter, he was arrested in view of the NPW and he was arrested on 22/1/2024.
Okay. He was on bail.
Yes,
My
yes,
lord.
he was on bail.
Annexed to is the bail.
The petitioner was on bail. Bail. Nothing could be seen in the what have you filed? I don't know. Not single line, even the number can't be.
Annexed to one annexed the bail order, my lord. On a
That's
bail.
right, but I can't read it anyway. The petitioner was granted bail on 18/8/2011
Yes.
My lord.
by the coordinate bench in BLAPL number 12802 of 2011.
My lord.
Since he has not appeared before the court, NBW was issued against him and he was taken into custody. You have applied for regular bail?
Yes.
My lord.
That has been rejected.
He has then the petitioner applied for regular bail before the court below.
Assistant Session Judge
Court
Attomali.
below.
Yes.
By order dated 22/1/2024,
Yes, yes.
the Assistant Sessions Judge Attomali in CT bracket S case number 33 of 2011 rejected his plea. Therefore, he seeks indulgence of this court. The petitioner is in custody since
22/1/2024.
22/1/2024. First लिख दो, he is the first paragraph is granted.
Yes.
Granted. Yes.
Obliged, my lord.
Item 20.
Please, your lordship. This matter arises out of Chawla PS case number 315 of 2023 under
Yes.
section 420, 468, 471, 294, 352, 121 and 34 of IPC.
Okay. What have you done?
Your lordship, the allegation is that the petitioner along with another co-accused has taken some spurious golds and has given loans against them. The petitioner being the branch manager and another co-accused being the joint custodian of that
branch manager of which bank?
Muthoot Finance.
Muthoot Finance. He has given the certificate that this is genuine. The gold is genuine, for which this loan has been sanctioned.
Okay.
But
He is the bank officer.
Yes, yes.
He is sanctioning authority.
Yes, yes, yes.
Your Lordship, he is the bank manager. But there is a goldsmith who certifies that this is the genuine gold. The branch manager has no occasion to know or verify the
You are
fact
in
that
custody since
14-1 and the co-accused has already been released on bail by anticipatory bail 1372 of 2024.
Copy होना चाहिए सेटा.
right now.
Of 14-1 2024.
14-1 2000. Look, write down. The petitioner is an accused in FIR number so. The allegation against the petitioner. The petitioner is the branch manager of Muthoot Finance Bank. Huh?
Yes.
Muthoot Finance Bank. What is that?
Muthoot Finance, sir.
Muthoot Finance.
Finance.
It's a gold lending company.
Finance. It is alleged that on the basis of forced certification regarding the genuineness of the gold,
Yes.
he has granted loan by accepting the mortgage of
Spurious gold. Spurious gold.
accepting the spurious gold as a mortgage.
Yes, yes.
Mortgage.
Yes.
Mortgage. Huh? The Learned Counsel or petitioner submits that the goldsmith who has given the certification on the basis of which he has sanctioned the loan has already been enlarged on bail.
No, he's not the goldsmith. Goldsmith has not even in fact apprehended. The joint custodian is
And
apprehended.
the goldsmith has not yet been apprehended, whereas the other co-accused persons have already been enlarged on anticipatory bail.
Yes.
And he has placed on record the orders. Huh?
Yes.
You have not placed on record any order?
We'll just give it right now.
What is this?
Because yesterday or day
has
before.
already been granted away. Mr. Maharaja appeared for the state and submits that since the allegations are serious, stringent conditions should be imposed in the
What
event,
investigation is going on?
in the event they are enlarged on bail.
Yes.
And there should be a direction for cooperation, direction to cooperate with the investigation.
Yes.
Taking into consideration the paragraph for the and same. Sorry,
21.
yes.
My lord, Jaspur Excise Police has seized 40 grams of heroin from the possession of my accused. The quantity is lesser than
Investigation on.
Heroin.
already more than 3 months detained.
CD.
Yes.
I'm calling for CD. It is heroin. Yes. Next.
22.
May I please, Your Lords?
Alleged
offencer under section 20B2C and 25 of the NDPS Act. He is in custody since 13th of September 2023.
13 September 23.
Yes, ma'am.
What is the allegation against him?
Allegations that two persons were coming the bike at night time and they were apprehended, and one of the bike rider has been eloped from the place, and the person who was sitting behind was arrested.
Who are you?
I
was-
am the person who was sitting behind.
Yes, yes.
Panch.
Man of Andhra Pradesh, it lost him by at least one chance be given to complete the investigation. It's a investigation going
What
on.
is the recovery?
About 42 kg, 300 gram ganja. So at least,
complete investigation.
yes, yes. After completion, he should move the
You-
application. Renew his application.
I'm just recording it, disposing it up.
Yes,
Wait and
yes,
revive the Arab.
yes, yes.
The recovery, the petitioner is accused and sorry, from the conscious position. It is alleged that from conscious position of the petitioner, 41 kilo,
42 kg, 300 gram ganja.
42 kg from 300 gram of contraband was
Yes,
seized.
yes,
So the investigation is still going on.
yes.
Learned Counsel for the petitioner seeks to withdraw this petition to revive his plea of bail after the charge sheet is submitted. With this liberty, the petition is disposed.
Obliged.
23.
23, my lord, case diary may be necessary.
Yes.
Case
diary.
diary may be necessary.
Yes, Daddy, and Lordship may kindly direct a list this matter along with the BLAPL number 1023 of 2024.
Right now.
Yes.
10.
1023 of 2024.
He's there, call for this, yes. Next,
24,
password,
25,
password,
26,
password.
27,
I think notice is not sufficiently noted by the, yes, next. 28.
28,
May I please, Your
Yes.
Lordship? The petitioner is arrested on 2/1/2024 for Your Lordship on the ground of commission of offense under section 20B2C. Your Lordship, I am traveling on the truck and I am apprehended after few days.
You fled away from the spot.
It is the accusation of the prosecution case, Your Lordship. And
Also, may kindly taken up along with BLAPL number 10553 of 2023 and BLAPL number 11750 of 2023.
There are two.
two BLPLs filed by other co-accused persons on whose allegations my name.
Being dealt with by whom?
Honorable Justice S. Ratho. S. Ratho.
It is pending, Your Lordship. That is.
It is in her assignment.
Yes, sir.
That is pending.
That is pending.
Not assignment, but that is pending.
Pending,
Because
Your Lordship.
earlier listed before that court and
Please
Yes.
the present petition along with the
BLFL number 10553 of 2023 and 11750 of 2023.
yes. Next.
29,
Obliged.
Lordship, kindly taken up the matter next week.
Adjournment.
30,
I think 30 mile kindly withdraw.
Withdraw.
Mind.
As soon as.
31,
May I please, Your Lordship?
Yes.
20B to C2B, 15 kg of ganja and petition with custody in 31/2024.
31.
2024.
Yes, it is 15 kilo.
Yes,
Granting.
my lord.
Okay. Same the condition. Huh?
Obliged.
You contravened.
32,
May I please?
Yes.
Number 376 2N reduce section 6 of the POSCO Act.
CD may be called for.
Yes.
3.
Yes.
363 initially, initially 363 elopement,
Right.
and thereafter subsequently turned to 366, 376 2N and 6 of the POSCO Act.
And 16 years minor car.
Call for CD.
As per the statement 161 statement,
164.
164 nahi aega main 154 they have to get.
CD Mogant.
Yes.
Yes.
CD along with 164.
Obviously. Yes.
33, 33,
Passport, my lord.
34,
May plus, my lord.
My lord, I may be pardoned, my lord. Item number 1333, my lord, which is my learned friend is being passed over, my lord. That is the 12 years girl, my lord, and 10 POXO, my lord. Here also maybe CD may be called.
No, CD 32. CD. Yes.
34,
34 minutes, a Belgium matter. He was on bail. Subsequently, due to non-appearance, NBW was issued and he is taken into custody on 18/7.
Right. The petitioner was on bail. First paragraph same. Petitioner is recused in the Dismissal case. And next paragraph, the petitioner was on bail. Why order dated?
He was bailed, my lord.
Regular bail. Order dated.
Really, I am mentioned in paragraph 3, my lord.
You tell me the date.
Yes, my lord. Date is a
17/12/2015 bail paitile.
17/12 regular bail.
And NBW has been issued.
Due to his default in appearing.
NBW has been issued, my lord, 11/7/2022, my lord. 15 to 20.
And he was taken into custody.
18/7/2023.
He was taken into custody on 18/7.
23.
23.
18/7/23. So next, the petitioner applied for regular bail before the court below. By order dated 22/1/2024. The learned additional sessions judge, some special judge, POXO, Bhavani Patna, in city case number 67 of 2014, rejected his plea of bail. Therefore, he seeks indulgence. Granted. Granted. No, this is bail. Bail jump, but he was arrested and thereafter same bail. Granted bail. Okay.
35.
May I please, your lordship? My lord, it's a excise case. Offense alleged is under section 20B2C of NDPS Act. Quantity of ganja involved is only 21 kgs. And so far as the present petitioners are concerned, they are in custody since 2nd of December 23. And in the meantime, final PR has already been submitted.
Second
2nd December 23.
2nd December 22 custody.
23, your lordship.
23 custody. Charge sheet filed on
5/1/24.
5/1/24. Granted.
Obliged.
With 50 recovery kete?
21 kg of ganja.
21 kg ganja. Recovery. With the same condition.
I would like
36.
My lord.
Here is also, my lord, CD is required, my lord. 363, 366,
36, huh?
My lord.
CD.
Yes, ma'am. Saw that.
We are taking it. No problem. Yes.
37.
May I please, your lordship, my lord, I'm sorry, I may be pardoned to.
All right, sir.
Actually,
Yes.
it's an allegation under the OPID Act.
Yes.
It's a purely of civil nature. Allegation is that they advance something for providing some housing accommodation because of non-sanction of the project by the development authority could not be completed in time. So they rushed to the police and registered a case.
How many cases are there against you?
Only one case, there is no antecedent. There is
You are in custody since?
I am in custody since 1st May.
1st February.
Sorry,
1st February.
1st February. I'm sorry, 1st February.
1st February.
My lord, I may be pardoned to say,
Yes.
my lord. My lord, this matter is belong to the OPID matter. And there is for OPID matter, there is the another advocates are there, all other advocates. And also CD is required also.
I'm just calling for CD and putting it next week. OPID lawyer is not there. Next week. Call for CD and next week.
OPID advocate, my lord, BN Bhuya.
Mr. Bhuya, record his name, Mr. Bhuya, in the cause list. And I'm calling for CD and I'll list it next week.
Lord, next week, can a date be given? Because next week my travel is
12th.
12th, 12th.
Yes.
Diploma.
38.
May I please, ma'am? 30. 302 allegation is there.
It is a matter of 302, my lord.
302 is there.
CD
might
is
be
there,
there.
my lord.
CD.
CD is there, my lord.
CD. Yeah, if the CD comes now, I'm putting it next week or
Yes, my lord.
next to next week.
Yes,
So that at least once it is
positively, my lord, positively.
Yes, we are that way.
My lord.
Yes. Next.
39.
39. No one. Yes. 40.
40.
Also.
41.
41, my lord. 10 gram of brown sugar, my lord. Costed since 9/1/2024, my lord.
How much?
10 gram of brown sugar.
My lord, out there, as per the order of rejection order, my lord, court, learned court
Yes.
below, my lord, there are 3 criminal antecedents and out of 3, 1 is the same nature of
All for
allegation.
CD and
Yes, my lord.
give little longer day.
42.
May I please, Your Lordship?
My lord, round figure wala long day.
My lord, 302, I think CD is required.
42 CD. All for CD.
43.
43, my lord. Victim is the informant.
Hmm?
Victim is the informant, madam.
Hmm.
She stated that while she was working in, my lord, Kerala, the present petitioner went there and the relations were developed. Subsequently, they married and they returned to the village. And after some days, there was a disturbance and the present petitioner, my lord.
My lord,
left
here is also CD is required, my lord, 164 statement.
Show me the one. You have 164, read it.
No, 161 is.
If this is the case, then I'll grant the bail.
161 is with me.
164 is required.
No, not with.
Next week.
Yes, my lord.
Next week.
My lord.
Public.
I'm putting in next week.
Yes.
Yes.
44.
May Lordship.
Yes.
Lordship, present petitioner is a minor school teacher and judicial custody.
In scheduled caste and scheduled tribe.
No, my lord.
No, what is this allegation? This no, no will not make no.
Let's see, ma'am, I am submitting. Present petitioner only introduced the victim.
Where she show me the.
Let's do kindly glance to the rejection order, Lordship.
Yes, show me. Yes. Yes.
Page 15, Lordship.
You are Brindavan Menka.
My lord.
Yes, read it. Petitioner is completely innocent and no way to connect it with the commission. Read it. And you start researching here.
Lordship.
Bail matter, 2 seconds matter. You start reading here now.
Sorry,
show me the relevant part and get the bail.
Let me say. CD may be
CD call.
Yes.
Not prepared, therefore.
Yes. Yes.
Short date, Lordship.
You have to suffer like this. Bail matter you are reading here. To come prepared, what is the allegation? At least you should be. It should be in your tips. All for kidding.
Present petitioner only introduced.
No, I have adjourned it.
So
you should know the.
On
90 matters are listed. If I'll waste time like this, and you start reading here, what will happen? Get ready. Next. Yes.
45.
Let's kindly date fix, Lordship.
He'll give it. Yes. 45.
In this matter.
He'll give a date. Don't worry.
In this matter, your lordship was.
Give it next week. The teacher.
In this matter, your lordship was pleased to call for CD on fast.
CD is there.
What is the allegation?
My lord, allegation, my lord.
376.
In this case, Lordship, I
Wait a minute.
You are appearing for?
for informal, Lordship. Can I take an adjournment next week?
He is in custody. You will see.
I'm in custody.
Let us see.
My lord, what happened? Here, informant is the mother. The age of the victim is 15 years, 6 months. Age of the accused is 18 years. Marriage was solemnized in presence of the family members of both sides.
164, read it out.
Yes.
Yes,
Lordship, our last occasion.
Read it.
The main thing is photographs.
Overall idea I want to say.
Lordship may see the
Consensual thing.
entire photo.
The bail matters will be taken up first.
I am sorry, my lord, I have not.
That is
Obliged.
everybody might have missed it.
My lord.
Today first.
My
time.
lord.
Yes.
Obliged.
47.
Yes. Please wait. I'll take it up right now. Please wait.
47.
Last time it is also non-appearance. The SST Act is there, but notice to go.
This is the bail application. Why should we wait? He doesn't want bail. He's not pressing. We'll pass it over. Thereafter, I'll dismiss.
Yes, sir.
Yes.
48.
Pass over.
49.
Pass. 49.
49 possible.
Pass over.
50.
14.
49.
49.
Last week it was before my lord.
How many bail matters are there thereafter? 50?
62.
After 62 item, I'll take. Yes.
49, madam.
Yes,
Here,
49.
Last week it was there, my lord directed to file the copy of the charge sheet, including the other FIR or the everything.
Yes. What
I will file.
What are the
Offense 307. And admittedly, the dispute, my lord, the petitioners are the father and son, and the dispute arose because of the fact that the informant has a grocery shop wherein he was, my lord, selling my lord, substandard items, for which it was opposed by the petitioner, petitioner number 2 with his son, and for which in the evening it is alleged that the informant, it is the arbitrate case, informant went to the house of the petitioner and abused the family member. That's why you are spreading all such things. And that's why it is alleged that thereafter, the petitioners who are the father and son, they went and they abused and made push and pull, and in their particular place, when the father of the informant is there, and there it is alleged that they picked up a broken brick and assaulted on the eyebrow, madam.
grievous? Sir.
Six individuals are
I was
implicated
not
on the case of the my lord, the injured. Out of them, my lord, one I am having my lord grievous injury. Just my lord above the eyebrow, my lord. That is my lord said that that is 1 cm, that is devious in nature, and other, my lord, 5 injuries are simple in nature, but those are in forehead, side of the forehead, knee, and side of the forehead, knee, my lord, toe, and like this.
But
And-
they went to, the aggressors went to their house
Their house.
That is,
without arms. What
That
is
is
their
there.
intention?
that is admitted.
326.
And the petition number 2 having 1 finger and stem.
But
506.
but without arms, they've gone,
They go on.
and you can presume that it may
No
be
intention to-
326 only, max to max.
10 হবনি কেন কথা হচ্ছে at best ballot kindly appreciate the particular eyebrow and on the same day same time he has been discharged, no hospitalization, nothing is there, and to
Same
attack the offense 326 there must be a hospitalization.
You are in custody since
My lord, I am in custody for my lord,
15-12.
1512?
22
Both
23.
Both the petitioners are.
We grant bail. We grant bail. But with condition.
My lord.
What condition you need, tell me?
Lordship may grant bail, lordship goes.
Every Sunday, for 2 months.
For 2 months.
For 2 months.
My lord.
Grant, okay. Japan is taken to be, he sustained, the informant sustained,
My lord.
how many is it?
Informant, father of the informant, he is 5টা 6টা injury.
Father of the informant
Aye.
sustained about 6 injuries, out of which 5 injuries are simple in nature. 1 injury is
On the eyebrow.
grievous.
My lord, straight true.
Grievous.
And he is
The petitioners have have attacked the injured person in his house.
Picking up a
help
broken
brick, with the
brick
help of a
lying there.
Since they were not holding any deadly weapon, while weapon, therefore, inference, prima facie inference could be drawn that the petitioner had no intention to kill the commit the offense under section 30. Sure. Grant.
Item 50.
May I please, your lordship?
50.
Yes. My lord. Initially, FIR registered 498 304B 306 4DP Act. Charge sheet submitted 498 304.
Who are you? Husband?
My lord.
Well, city is recording.
Right. I have this.
What is the offense? 306?
My lord.
Charge sheet has been filed by the 498 306 304.
304B is there.
No, my lord. My lord, kindly see the FIR. The petitioner lodged with another lady, the main cause of the suicide.
But 304B, 306. How can there be 306 and 304?
My suicide, my charge sheet, my certificate charge
Both.
sheet.
Either this or that.
I look at the certificate copy.
What is the stage?
My lord, let the city come, my lord. Yes, file
My
a
lord.
copy of charge sheet, my lord. I'll get the, my lord.
Trial
charge
not,
sheet below.
my trial not started. I can see the
Trial, I know, but
let the city-
let us see the charge sheet allegation.
Yes.
Charge sheet allegation. Let us see. Where is the charge sheet?
Well, started.
How can I read CD next week? Call for CD next week.
Sir.
12th. Give the charge sheet and all.
My friend has given.
No, given, already given.
30306 or 304B.
My lord, the 306, my lord, cause of death, my lord.
Suicidal hanging.
Asphyxia due to hanging, my lord. Suicidal in nature, that they have settled. But my lord, regarding the torture part, regarding dowry, my lord, that has to be borne out from the city, my lord. That is not there. I think the statements are there, my lord. But I think complete city is required because the statement of neighbors and some other. my lord,
Just check it
villagers-
up. I think he's entitled.
My independent witness statement, I may read.
I think he's entitled. Check it up next week. 12th, keep it 12th. Till 12th, be there. Happy.
7/6/23, my lord. Custody.
7/6/23 custody.
File. They see your prosecutors are so good. They don't want that you should stay for one more go.
Well, I have folded.
The accused right down. ये नहीं जाओ ठीक है और
Lordship, may recall our objection.
investigation has already been completed. Charge sheet has already been laid down for offences under section
4910, 304B,
306.
306, along with 4 DPR.
304 B भी लगा दीजिए 306 भी लगा दीजिए इसको 8 भी इसी तरह in custody since
7623.
7623 is the husband of the victim, husband of the deceased, husband of the deceased, grandly. Yes.
51.
May I please, your Lord? Your Lord, alleged offences are under section 399 402.
How many cases you have? So many cases.
My Lord, in fact, in the rejection order, it has been reflected as 14 criminal cases against my petitioner, your Lordship, in the first bail application.
Who is this Vivekananda Mahakot?
All are connected matters.
And,
My friends are appearing
all are
Well, from
all are accused.
from one place, my lord, 6 persons were apprehended, my lord. And they are showing different different antecedent of different persons, my lord. And my lord, only 399 402, nothing has been seized, only one iron rod and
lighter
pistol was seized from the possession.
In all the cases the same FIR, huh?
Yes.
They are accused in same FIR.
Yes.
Okay. What is the allegation?
My lord, in item number 1, my lord, that Subrajit Jana, 664, your Lordship.
Subrajit Jana. Yes.
My lord, he is having, my lord, 14 criminal incident.
Only. Okay. Next.
And my lord, that Vivekananda having no criminal incident.
Vivekananda likho. Vivekananda. 521. Take 1 minute. Was these matters any co-accused matter was heard by anyone? Any other court?
No, my lord.
Yeah, this is the Vivekananda mein no case.
No CA.
First one, Subrajit, 12 cases.
14 cases.
But in the meantime, he has been acquitted in 8 cases.
14 cases.
Madam.
Yeah, this is no case, huh? No, only. No other case. No other case. Next is.
My lord, that 521, no CA.
No other case. No other case.
But one duplicate pistol has been seized from his custody.
Lighter.
Yes, next.
My lord, that
Rahul? No, Pritam.
my lord, he is having no criminal incident.
No criminal.
799.
No criminal. Yes. And
My lord,
another one is
Suman.
Yogesh.
Yogesh has 5.
Yogesh has got 5 criminal incident.
No, Rahul भी है सर क्यों क्या?
Rahul Kumar Gota.
Rahul, my lord, no criminal incident.
Yogesh?
5 criminal incidents.
Yogesh, my lord, 5 criminal incident.
What are the allegations? Let us see now.
Another, my lord, the Suman Biswal is there, 696, my lord, and he is having no criminal.
No, but yeah, duplicate pistol was seized from.
Duplicate pistol was seized, my lord, from Vivekananda.
One lighter, my lord.
Lighter pistol.
Lighter तो लगता है.
पैसा नहीं लगा.
पैसा काटने नहीं. Only.
Okay. Yes. Now what are the allegations?
My lord, in a Scorpio, my lord, 4 persons, and in a 2 motorcycles, 2 persons are there, my lord. Totally 6 persons were gathered in a area, and police apprehended them. From their possession, my lord, one lighter and one rod was seized. And with this allegation, they have been implicated and forwarded to custody.
Yes, Mr. Prakash.
My lord, from Subrajit, my lord, that first well application.
What are the allegations? Let us understand what exactly the allegation.
My lord, they tried to commit docket, my lord. 399 is there.
They have congregated in one place.
And police getting information that some mischievous act they are trying to commit, apprehended them.
A splendor bike with parked and side and 2 number of people standing near the car and 4 near the car. Immediately they surrounded them and seeing the police party so. Yes. What do you say?
They are trying to come, my lord, for the purpose of committing docket from Boinda area. They have been congregated and, my lord.
Those are having, your lordship,
What will happen to the people those who have antecedent?
those are having criminal antecedent, your lordship may direct them to appear before the concerned PS.
6 months.
Say for a period of 6 months, twice in a week.
Then
Those are not having the criminal antecedent, your lordship may grant.
then you are talking about Subrajit.
And one of that Jogesh Sahu.
Uh,
Jogesh Sahu.
5 case. Jogesh
Yes.
Sahu.
Yes.
And Vivekanand.
Vivekanand Malad having no criminal incident, but the duplicate pistol has been seized from his.
तो आपको भी करिए 2 मास.
Yes, sir.
देखो ये सुब्रजीत फर्स्ट सुब्रजीत से ताकि बोलो
मतलब तगड़ा
ठीक है विवेकानंद को 3 मंथ विवेकानंद को 3 मंथ और ये योगेश साहू को ये 6 मंथ और ये ठीक है.
Your Lordship, in bail application number 836 of 24, instead of Hon'Ble case, there is wrongly typed automatic claim.
Same PS, so same in all the cases. PS same.
Wrongly typed, perfectly is wrong. That has to correct it, otherwise he'll get the wrong certificate.
The wrong, you have done wrong. Your client will stay a little more. What is the problem? Which case?
836 of
836. That is Rahul Kumar.
Yes, sir.
Rahul Kumar is typo error. Your office work also we have to do. That's the problem. Yes.
52.
May I please, your lordship? Last time the CD was called for in this case. The alleged offense against the accused is 363, 366, 376 2N, read with section 6 of POCSO Act. Charge sheet has already been submitted, your lordship, in this case.
What is the 164?
164 Malad, he has annexed. Page 50,
Six.
lordship.
Yes. Read it out.
56.
May I please, your lordship? Last time, your lordship, directed to collect the status
Out
of
of
the trial
24
court matter.
witnesses, 20 witnesses have already been examined.
21 witnesses already been examined by the court matter. They are up to now. No witnesses were made.
Yes. Out of 24, 20 witnesses have already been examined.
Your lordship may target.
Earlier, my lord, he was in bail, my lord.
Bail thelecom.
They are after non
210 kg total. 210 kg.
Oh, then forget it.
Target to
But in the fake end of trial.
My lord, this is a case, my lord, kindly see, my lord.
No, but don't show me anything. Out of 24 witnesses, 20 witnesses are examined.
Yes.
I will let you out, then you will never come.
My lord, 498 306, my lord, case, my lord.
It's 498.
My lord.
Kuda? Item setting.
56.
Yes, he is saying, oh,
I'm sorry.
200 kilo. What is this? 498.
498 306.
306, my lord.
Grant pay.
Oblige, my lord.
He is in custody since.
Posted, my lord.
But I'll put a condition. In the last stage of trial,
But-
if you
Full
appear
corporate
for
matter.
1 day also, your bail will be.
My lord.
Right.
There are no
Right
things.
now, grant the bail. He is in custody. Kabe?
There are no things.
There are no things. The petitioner was on bail. However, due to default in his appearance, NBDL was issued and he was taken into custody.
Yes.
The trial is at advanced stage. Out of 24 witnesses, 20 witnesses have already been examined.
21, my lord.
20
21.
21 witnesses have already examined.
Yeah.
The petitioner is granted bail subject to the condition that the petitioner shall appear in each date of hearing before the trial court, and he will not seek adjournment on unreasonable grounds. Non-cooperation with the trial will entail the cancellation of the
Bail.
concession of bail.
Yes.
granted to.
Yes.
Oblige, my lord.
Because generally, after getting bail, you will not go.
My lord.
So therefore, you be sure about it. Okay.
Oblige, my lord.
57.
May I please, your lordship? Case under section 457 380.
Custody since both the petitioner custody.
380.
Yes.
Yeah, what is the allegation?
Allegation, my lord, somebody has broke open the lock of the school gate, enter inside and took away 5 packets of rice, gas cylinder dita, pressure cooker 1,
School pilagar सब दिए school
Honda,
छोटे पिलागर
Honda
सब
pancho tray.
and it, trial is going on.
Okay.
Trial is going on. Cooperate with the trial without any.
He will cooperate with.
My lord, my
will not same condition.
My-
Same condition. Cooperate with trial.
Yeah, kichi chori.
Adjournment never नहीं जाएगी.
Gotela trial, I would have report to police because he is having criminal antecedent.
हाँ से
Four cases.
ये
Yeah.
Sunday को Sunday जी.
For 2 months. 2 months. 58.
May I please? Offense is 420. And I am custodian 5/24 and charge sheet has been submitted 23/24. And last
It is not there.
Offense of allegation code.
sir, allegation that I assured the petitioner assured to provide a house and taken away
Are you a
47.
builder?
Sir, no builder is a general person. He also assured to sell a plot that is 47.
Show me the allegation in charge sheet.
Sir, charge sheet have already filed and download, sir.
That's it. Can
They-
Read it out. Read it out. What is the allegation? Read out.
Sir, allegations.
टोंकड़ा दे दिया.
Forget about FIR. What has come against you? Just see.
Sir, that is I have assured to take given a house.
Read it out. Read it out, sir.
Sir, during course of investigation and examination, the Ajay Kumar Chaudhary as has a real estate businessman at Shastri Nagar and as per the discussion, selling said building Acharya Vihar and equity
How
has
much
been,
you have taken money?
sir, 47 lakhs,
lakhs.
70,000.
Keep something at least.
Sir, last occasion 19 to 24, the Honorable Court directed to deposit some amount in that
How
effect.
much
Sir,
is deposit?
5 lakh tanga.
5 lakh 47
47 lakhs.
5 lakh.
The local mola
Sir, father is admission in Apollo Hospital, sir. Sir, in sympathetic and sir, how after release on bail, I will give within 1 month 5 lakhs, sir.
और दया.
Sir, ଏବେ 5 ଲକ୍ଷ sir ଦଉଛି ଆଉ release ର 1 month ପରେ କି 2 month ପରେ sir ଦେଇ
Other side is to be seen, my lord. This situation is very bad because he has taken directly the amount, and the person who has given the money and his plight is
Sir, I
more
filed
than
the
the plight of this
Huh?
petitioner.
Sir, I have filed the affidavit in that effect.
No, where is the informant?
Informant is not
You
present.
not call,
Appear.
At least
call the informant.
Yes.
Next week I'll give you bill. Okay, counsel for the petitioner seeks to implead the informant in the present case
Yes.
as opposite party number 2.
Yes.
Let him do so during the course of the day, countersigned by him, issue notice,
Yes, yes,
file the process fee today,
exactly.
least on 12th.
Wow.
12th he will come with the draft, 5 lakh.
Sir,
I'll ask him to take it and let you out. At least let him get some sort of that he is getting some.
sir, I will file the drafts.
Come with the draft.
Sir, sir, kindly order may be reflect like
I remember it. Come with the draft, you get the bail order.
sir.
Section, you have to go to the section and correct it because there is no physical file here.
Right, sir.
And
I implemented party the informant.
and take out notice. The opposite party.
Requisites file कर दूँ तो कल ही.
Okay.
कल सब verify कर.
Today only you do it.
Sir.
Don't delay. Yes.
59.
Yes.
Petitioner is constituted since 13/1/2024 for alleged offence under section 20A for NDPS Act.
How much?
Like yesterday, Lordship allowed one of the co-accused persons bail application.
What?
360 plants जो है
Item
plants.
31.
Yesterday.
Item
ये
31.
plant route करना था.
BLAPL
से number टा कोई दे दो.
Number कौन?
Number टा.
BLAPL 583 of 2024.
583.
Three.
Oh,
Item 41.
ठीक है, कर दे. हिसाब कर दे.
Item
ठीक है, granted. And whatever conditions are there, same conditions.
Same. क्या order है?
You are one of the brother. Father owns the land where the cannabis were cultivated.
Item 41, yesterday list item.
अच्छा अपन number तो देले ना.
For the
60.
May वो lady below commercial quantity charge sheet has already been.
Anybody who will engage you will become poor.
Very poor, very poor.
No, more fees no, no.
None. Very poor.
After engaging you, everybody will be poor.
Automatically.
ଆମେ ତ ଏପର୍ଯ୍ୟନ୍ତ ତାକେ ଯାଇନୁ ଆଉ ଏଗନେଷ୍ଟ ଦି ସୋସାଇଟି ଆମେ ଏପର୍ଯ୍ୟନ୍ତ ଏଗୁଡା କନସିଡର କରିନୁ 152 ଗ୍ରାମ ବ୍ରାଉନ ସୁଗାର
No, 120.
କଣ 120 ଆପଣ ସେଗ୍ରିଗେଟ କରୁଛନ୍ତି
150.
One?
It is below commercial. 152.
ହଁ ସେଟା ମୁଁ ମନା କରୁଛି କି
ମୁଁ 152 କହୁଛି below commercial quantity charge sheet has already been submitted to all lady.
ଲେଖିଲେ କଣ ହବ 152 ଗ୍ରାମ ବ୍ରାଉନ ସୁଗାର ଆପଣ ଆସି ଆମ ରାଜ୍ୟ ନଷ୍ଟ କରିସାରିଲେ
ଆରେ ଓଡିଶା ଲୋକ ତମରି ଘର ପାଖରେ
That's the problem. Brown sugar I don't entertain.
lady for that reason otherwise I could not have. Your lordship may kind impose any stringent condition. Oh lady
Outsider?
नहीं a local man.
Yes,
subject to verification of a criminal antecedent.
My lord.
Subject to verification of criminal antecedent. Since the recovery is
152 gram.
152 gram, which is less than the quantity, granted be. With condition, all conditions. 6 months? 6 months?
6 months. 6 months.
6 months.
Shall appear before the consent fees.
You are lady, you can go. No, you
Yes.
have no work. At least you should be checked. Okay.
61.
61.
ବେଲଜିୟମ ମ୍ୟାଟର ରେଗୁଲାର ବେଲଜିୟମ କରୁଛି ତଳ କୋର୍ଟରେ ଅବଜେକ୍ସନ ରେଗୁଲାର ବେଲଜିୟମ କଷ୍ଟଡି ରହି ରହି since 21/12/2023 dispose of loss. Why should the will you wait for the defense counsel?
Same.
Yes.
He was on bail.
He was on bail. He was in custody till after being arrested 21/12/2023.
No, the petitioner was in custody.
21/12/2023.
21/12/2000. Thereafter, he got regular bail. He was admitted to regular bail.
No, he was on bail prior to this. After being released on bail, he could not able to appear before the court.
The bail date when you
bail date ता धरे ऐसे लिखी ना दी कोर्ट कौन लिखो चंदी
the petitioner is accused in such.
केवल गोटे लिखा है on repeated calls on 21/1/2023.
1 minute. 1 minute.
Yes, that you will see.
Petitioner was on regular bail.
Yes.
However, on
21/1/2023.
21/1/2023.
The case was posted for hearing of a charge.
The case was posted for hearing on charge.
On that day he was absent.
However, the accused did not appear. Therefore, the NBW was issued and subsequently he was arrested.
And he was in custody since 21/12/2023.
He was arrested and he was arrested on
21/12/2023.
21/12/2023. The petitioner moved regular bail application before the court below.
Yes.
On
10/1/2024.
Yes. The learned which court is this? Learned additional sessions judge Sambalpur.
Yes.
In ST case number 37/21. Rejected his regular bail application on the ground that repeatedly he has been abusing the concession of bail granted to him.
Right.
Granted to him. What are the offences?
399,402.
Taking into consideration so he is granted bail with the condition that he shall appear before the court. Trial court diligently without fail, non-appearance of the non-appearance of the petitioner before the trial court during the trial will entail the cancellation of the concession of bail granted to him.
Yes.
62.
My lord, offence is 454/380 IPC, my lord. He is in custody since 22/12/2023, my lord. The allegation that he has entered into the house and taken out the golden necklace and ring, my lord. That has been recovered from which was pledged before open number petition.
Where is the FIR? Where is the charge sheet?
Your lordship may kindly turn to page 9. Page 9. Your lordship got it?
9, yes.
Page 9, para 3.
Yes.
Start from what? Peruse the case record. Everything has been mentioned. May I read, my lord?
Yes, yes.
Peruse the case record as per the FIR allegation. The accused petitioner Bada alias Arjunath Digal
had access to the house of the informant and he had sufficient knowledge about the day-to-day affairs of the informant since he was engaged by the informant for preparation of a door of his house. In the absence of the informant, his family members, he has committed the theft of gold necklace and gold ring from the godress of the informant by opening the house lock. After committing the theft, he placed with the accused petitioner Lakshman Pradhan. The accused petitioner Lakshman Pradhan, without verifying any document toward possession of the gold necklace by the accused petitioner, Bada alias Ajarath Digal, kept in as a security. Investigation in this stage, the golden stole has not yet been recovered.
Then he is Lakshman.
Yes. But he has Ajarath Digal.
Both of them are.
Yes. Yes.
Petitioners.
Subject to verification of the criminal antecedent, cooperate with the investigation.
Strategically, you are making mistake by moving together.
Yes.
Why are you moving together?
It was moved before the court below, my lord. That is the whole difficulty.
Strategically, only the mistake.
My lord, it was moved
The
before.
allegation against Lakshman is he has
Received on pledge.
received the gold ornament which was theft.
Pledged before he.
And along with it, then you are confirming things.
Difficulty that both had moved the
Eita
petition.
nejo ye allegation ta nejo iti page 9 re peruse the record sheet nejo. Peruse the allegation. Petitioners are the accused in FIR number so. Second allegation against the petitioners are as such in the key clear. Para 3 page 9. ठीक है? Grant for the bail. What are the conditions?
Condition appear before the PS once in a week. For a period of 3 months.
3 months.
Yes.
Once in a week for 3 months.
And shall cooperate with the investigation because investigation is going on.
Investigation is still on. He shall cooperate with the investigation. Non-cooperation, non-cooperation in the investigation or violation of the bail conditions shall entail
Cancellation of bail. Yes.
Yes. 39.
12 kg ganja were
39.
39 and 40. Arising out of same FIR, my lord. 2 application. 12 kg ganja. Both were in.
Both of them are accused.
My lord.
39, 40.
My lord.
Yes, my lord.
12 kilo.
My lord.
Yes, my lord.
Or 12 kilos.
Yes. I told 20 is a bail.
20 is bail matter?
Yes, sir. Bail.
Yes, tell me.
27.
Tell me. Yes.
27. What is the Belgium matter?
Belgium?
Yes, sir. Earlier was in bail, Lord Chief. And because you guys.
Mr. Rahul, just check it up.
27. Yes.
27, huh?
Yes, sir.
Belgium, he says Belgium.
Yeah, earlier was bail. And the duty, the meaning of the charge, he has absent because he migrated from other state, Lord Chief.
What are the offenses?
Offense, Lord Chief, is 3762 and the 6 posted.
Where is the bail order you show me?
Order, Lord Chief, and the bail number 9958 by 2019.
Okay, he was on bail here.
Yes, Lord Chief.
Right.
No, by the
order dated 9/12.
Yes, Lord Chief.
Petitioner rejected in such case. By the order dated 9/12/2019, the petitioner was enlarged on bail by the coordinate bench of this court while allowing his bail BLAPL number 9958 of 2019. However, he remained absent in the court below, which led to issuance of NBW against him. And subsequently, he was arrested on 2/2/2024. When he applied for the regular bail before the court below, his bail application was rejected on 6/2/2024 on the ground that he has been repeatedly repeatedly violating the bail conditions.
Bail conditions.
Bail conditions.
Yes.
Taking into consideration the fact that the coordinate bench had already enlarged the petitioner on bail, on merits, I'm inclined to grant him bail with the condition that he shall not violate any condition imposed by this court, any bail condition imposed on him. violation of any condition imposed on bail will entail the cancellation of bail. 2 months କଣ କରିବେ ଆଇଲେ କିଛି ଦରକାର?
Obliged.
Every date appearing you would appear. That's the right of every date appearing will appear. Non-appearance and without unreasonable condition will be fixed adjournment.
Obliged.
Yes.
the moot question involved in this
My lord, may
case.
kindly see the last order 1 to 24, my lord. My lord has directed the SP Excise to dispose of the application filed by the petitioner under annexure. My lord, that instruction I don't have.
Maybe that this
It-
application filed by the petitioner has been decided by Superintendent Excise in view of the fact that the written is pending. Don't forget this vote is granted April stay at same time. Yes, directed to consider.
My lords, your lordship have been pleased to direct for the release of the vehicle, and accordingly they have passed order on 1st of March. But physically they haven't delivered the vehicle because owing to some personal difficulty of the IO. So on Wednesday they are supposed to release. So that matter is settled, my lords. But the base moot question involved in this matter is that in view of the order passed by this honorable court with regard to a batch of matters wherein the insertion of molasses is under challenge.
Why are you getting into all these things? You
My
got
lords,
a vehicle. In so far as this petition is concerned, it is the release of vehicle. You have got it.
yes, my lords, and also I have challenged the initiation of the confiscation case. So let this matter be kept pending along with the main case.
Adjourn it to April. Let us see.
My lords, obliged, my lords. Interim orders to continue.
Interim orders to continue.
Obliged, my lord, deeply obliged.
Item 2. Lordship, item 2, referral and adjournment money. Yes, madam.
Yes.
Item 4, somebody has mentioned already. Item 5.
Yes.
May I please the lords? My lord, I seek for an adjournment.
Okay. You
Grateful.
mentioned. Yes.
Item 6.
Yeah, my lord, the last occasion was pleased to direct my adjournment to obtain instruction in the matter to the records.
Item 6.
Here is a case, my lord. My lord, I have challenged the order passed by the land magistrate, wherein he has allowed the application filed by the public prosecutor. My lord, may kindly see.
My lord has directed for the city, my lord. That has not from me.
Interim order, my lord, we passed it. Because in the process of getting city, my lord, my case will be infructuous. My lord, why I am saying so? My lord, after examination of 3 witnesses, an application was filed by the public prosecutor under annexure 1, my lord, may see page 8.
Yes.
See page 8. During trial, PW3, namely Manoranjan Bagh, deposed before the Honorable Court that he has submitted the documents regarding direction to release the pangolin, treatment of pangolin, videographs and photographs in relation to release of the said pangolin to the IO. Further, it is ascertained from the record that the requisition letter relating to seek assistance from Tahsildar so and so. But nothing is there on record. This application was filed when the public prosecutor could know that nothing is there to put me to tax. But let me see evidence of PW3.
This application was allowed.
This application, but I filed the objection. This application has been allowed.
Show me the order. Show me the order.
Well, let me see.
Page 10.
Page 10.
Yes. Come on, let us see. You are agreed by this order.
Ballot.
Let us see. Why? It is contained by the
Ballot. Let's see the at page 11. The
direction to release the pangolin, treatment of pangolin, videograph of the release of the pangolin to the IO. For that, it is attained from the record that the petition relating to the capacity of the investigation. Further, the document was not fully approved by IO case. Support of the contingent petition should be accepted. So on so on so. Legal counsel required into objection stating that this case was style of case comments and all these documents to the IO after he says that PW3 is the IO.
Well,
he says that I have given all the documents.
Ballot may kindly see page 20.
Yeah,
Page
but
20
which is
cross
not
is it?
placed in the charge sheet.
My lord, may kindly see page 20.
Page
Why
20.
why this application has been filed after examination of PW3? I'm
Page
saying
20.
page 20.
Yes. Page 20. Okay, come to page 20. Right.
The said videograph and photograph of the release of pangolin were submitted to the IO, which is not present in the record.
Which question?
Paragraph, sorry, 11.
11.
My lord.
The said videograph and the photograph of
The release of the
pangolin were
pangolin
submitted to the
IO, which is not present
in the record.
My lord. Record रे नहीं.
Right.
उठ आने में तैयारी करके आने में निश्चय to bridge up the gap.
My lord, that takes.
And the next, my lord, 12.
Precisely, you are asking these documents which are not there on record, and the case is pertaining to which year?
My lord, it's a case of 20.
20.
And the last part of
evidence is
23, my lord.
recorded on
And this
July 23.
This practice has been deprecated by the apex court also, my lord, time and again.
If he had given this photograph and all, it should have been there in the part of the record.
Yes, my lord.
If the part of record is not there, today you can't.
That's why my lord has called for the city, my lord, case record, because
statement
my lord, they cannot tamper. CD is there, my lord. They will write all those things, and column, the CD column is there. They can tamper, my lord. Your lordship, that's why, my lord, after going through this, my lord, the submission of my senior friend, my lord has called for the city, my lord. Your lordship may give us some time.
Bring on 13th.
Yes, lord.
1-3.
Yes,
1-3.
1-3.
1-3. No further adjournment.
Yes,
taken. Mr. Prora seeks last opportunity to file the CD, bring the CD in the present case. By way of last and final opportunity, date is fixed for 13th. 13th. No further adjournment shall be given. I will, otherwise I'll say.
My lord. Otherwise, my lord, no case, my lord. I don't have.
You, because see,
Yes, my lord.
he specifically says.
My lord, if that will be there in the record, it will be there.
Otherwise, no. You can't manufacture something. And
since charge sheet has been filed in the court, they cannot tamper. Your lordship, rather, calling for the. That's why, my lord, if your lordship call for the photocopy also, that will be, my lord, very much.
But you can verify and tell.
Yes, I will get it.
Yes.
Item 8.
7
item. 7 item. Item 8, may I please, lordship.
8, yes.
8.
That's my lord, absconded NBW, my lord.
NBW.
Yes,
NBW passing for
how many? 1, 2, 3, 4. Okay, how many you are there?
There's a
1. You are on bail?
No, lordship.
No.
No, lordship.
The grab of my lord, 482, my lord, they are come.
NBW.
387 allegation is there. 387, 27 arms act. And the absconding, my lord, and after the absconding, NBW has been issued.
Okay, you appear on today's court, on or before 30th of here. Appear and seek remedy available to under law. And 1,000 cost, NBW can check. NBW issued on 29/9/2022. Petitioner is not in bail. Petitioner is not in bail and he is an absconder. And on instruction, he submits that his client would be appearing before the court, jurisdictional court, on or before 30th of March, and avail remedy under law. The NBW is kept in abeyance till 30th. Execution of NBW issued on 29/9/2022 is kept in abeyance till 30th of March. Go and appear, seek remedy, whatever remedy you are.
Item 9.
May I please, your lordship. My lord, petition or challenging the order of NBW. Order of NBW dated 16/11.
You are on bail?
My lord,
138 case, my lord.
Was on a warrant was.
Okay, cancel. Bail, petitioner was on bail due to non-appearance. NBW was issued on 16/11/2023 and 30th. Take it. 138 matter. You are recused. What is the check amount?
2,50,000.
500.
Dispute in between the bank and loan.
Give 500. Yes.
Item 10.
Yes.
May I please, lordship.
My lord, the petitioner challenged the order dated 5/9 to 24 MDW, my lord.
You are in bail?
It's a complaint case, my lord.
Complaint may once case, my lord.
Okay. The present case is the 1 CG case number so and so, so and so. And due to non-appearance, NBW was issued on 5/9/2022. Now on instruction again. How much you will pay? 500. 500, pay 500. 500.
Oblige, my lord.
Yes.
11.
My lords, the petitioner swear on bail due to non-appearance NBW has been
On
issued.
bail, give the date.
2518, my lord, bail.
Huh?
2518 is bail order.
2518 bail order, NBW order
21/9/19.
21/9/19. 19.
9
Yes, lords.
500 each.
Yes.
Yes.
Item 12.
Belgium matter, he was on police bail, my lord. Earlier he was on police bail. The envelope was issued on 25 to 21.
He was on bail. He was on bail.
Police bail.
Yes, yes.
NBW 25 to 2021.
41.
And how many of you are there? 500.
SC Act is there.
500. He will appear and seek remedy.
Yes, your lords.
Item 13.
Pardon my appeal. I have challenged the order of NBW, my lord. After charge sheet, he was not on bail, my lord. Yeah.
Earlier you were on bail.
Yes, my lord. He appearing for appear to before
No,
the
someone
court.
was issued,
And
you have not
NBW
appeared.
issued against him. Someone
NBW issued, he was on bail.
he may be surrendered, my lord. After charge sheet, my lord, he may be surrendered, my lord. Before charge sheet, he granted bail, my lord. After charge sheet, while granting
You
some.
do whatever. I am just saying it. You go and appear and do whatever. That's not a bail court.
Yes,
I'm only accommodating you by
Surrender, they go on bail.
surrender and you
Really,
apply for bail. Okay.
Oblige, my lord.
Same order. How much? 500.
Yes, oblige.
Item 14.
My lord. NBW issued by the court village and not challenge, my lord.
You are on bail?
Yes, my lord.
When?
I was on bail since 6/11/2017.
6/11/2017 bail. NBW.
My lord, 6/11/17, he was granted interim bails.
Interim bail.
13/12/2023 NBW.
Yes.
Okay. Where is that? And 500 each.
Yes, ma'am.
500 each. Yes.
15.
It's a Belgium matter, lordship. Earlier he was on bail, lordship. 24/12/2019.
24/12/19 bail and 15/12/23 NBW.
Due to
500. 500.
Item 16.
It's a Belgium matter, lordship. Earlier he was on bail, lordship.
10/10/2002.
Lordship.
Bail. 10/10/2002 bail and 22/11/23 NBW.
Yes.
Okay. 500. Yes.
63.
May I please, your lordship? May I please?
Yes.
My lordship, I am appearing on behalf of Mr. Rajavrat. He is currently not well, so I seek for an adjournment.
Okay.
And my lordship, I will further like to bring before this honorable court that on the last occasion, my lordship has asked for the certified copy of the question to be asked in the cross-examination. My lower court counsel has provided for the certified copy and it is not being provided by the lower court counsel. So I seek further 2 weeks time, my lordship.
It will be urgent, do needful, whatever.
Much obliged, my lords.
64.
64 may bless you. In the said case, my lordship, the present petition challenging the order of the cognizance dated 7/7/2020 passed by the Lord SDGM Balasur, which is annexed in Annexure 2, page 27, my lordship.
Where is the charge sheet from?
Charge sheet has been charge sheet dated
Where is that?
page 18. Page 18.
Yes.
Against this person under section 294, 506 and 34 IPC. In the said
Why should I interfere?
Interfere, my lordship, the case, the date of occurrence is 4/3/19 and date of FIR has been registered on
5, 2019. After 2 months, the FIR has been registered. The case arises out of civil dispute and the civil suits is pending. And in the said case, my lordship, the prima facie of the offences under section 294 is not made out against this present petition. In order to prove the same, the prosecution has to be prove the prosecution the word public place, which is defined under section 12 of the IPC, my lordship, and that has been means any class of the public.
This was the earlier approach before this honorable court, and this honorable court has been pleased to.
Under section 12 of the IPC means
You came earlier here. What happened?
Exactly the same. And this honorable court has been pleased to direct the petitioner to raise all these points at the premier.
Obviously, that's what I intended to say. Where is
Again,
that order?
Again on the same point.
Where is that order?
CRLMC 196 of 2022.
Why have you come again? You are supposed to argue all these things at the charge stage.
That in that earlier, my lordship, that a copy of the in the said case, my lordship, I have challenged the annexure 2, my lordship, the Cognizance order.
Where is the earlier order? You tell me. Show me. Earlier you approached for the same thing against Cognizance. The court said that you argue all these things at the stage of trial.
Yes.
Framing of charge. Instead of doing that, again you have filed.
Now, Cognizance has been taken, my lordship. Cognizance has been taken under section 290.
Argue at the stage of.
No, not my lordship. I am argue only that Cognizance.
Where is the earlier order you show me?
That order, my lordship, pardon, my lordship, that order is not.
You show me. Earlier you approached that order.
That order I have not. The order copy I have just.
Adjourn it to May.
File your order.
This is the wrong practice. You have approached this court. All the orders should be there. What is this? You are young
My lordship.
lawyer. Why are you doing all this?
Not my lordship. I am praying before my lordship. I am submitting that if the under section 294 is not made out against this present petition, that is mentioned under section 12 of the IPC, my lordship. That only.
Have you seen this order? Have you gone through this order?
That order I have gone through, my lordship.
Then how will you get out of it? How will you get out of it? It says, permitting the petitioner to raise all the pleas urged in the present petition in appropriate stage of the trial court, and criminal MC is disposed of. The interim order passed earlier stands vacated. A copy of this order be communicated to the concerned trial court forthwith. This is the order.
Yes.
Again, you are repeating. This order was passed on 4/7/2023. When you file this petition, this item 63, na? 64. When have you filed this petition? Just see.
I'm 23/8/2023.
24/8/2023. Just 15 to 20 days.
What is this? Why are you doing all these things? You are inviting cost, in fact. You are a young chap. I'm not doing anything. You simply withdraw.
I will
urge all these points at the appropriate stage.
Adjourn this matter, my lordship.
No.
Adjourn this matter. I will.
Write down.
My senior will appear, my lordship. Adjourn this matter.
Senior will not improve your case. Senior will invite further cost.
Not
You
my.
are appearing, so therefore I am giving some respite to you.
Only adjourn this matter, my lordship. Adjourn this matter. This my I am.
Do you want some cost?
Not my lordship. I only adjourn this. I will satisfy my.
Senior come, I'll pass it over. Senior come, I'll impose a cost of 10,000.
Not my lordship. That is impossible. I am unable to. I only can solve. You adjourn this matter, my lordship. I'll comply with the order copy.
Pass it over max to max.
In 2 weeks time, my lordship, I will.
Max to max, I'll pass over.
2 weeks time.
Do you want no question? Why this? You know, burden in the court.
Not burden, my
Because of these false cases, you obtain in the first case, you obtain stay, enjoyed the stay for a longer time. Now stay is vacated. Again, you are filing. Trying luck.
I'm satisfying. Just one minute. I don't know. 1 minute. In the said offense, none of the offenses is made out against this person.
That's right. You are absolutely correct. But we stayed because of this order. You have to argue all the thing in the trial court.
Even 506 is not made out.
Again, you don't understand what I'm saying. Why are you creating problem for yourself?
Not creating. Adjourn this matter. I will satisfy.
No question of adjournment. I am telling you, no question of adjournment. In the face of this order, it can't be adjourned because it's a burden of the court, and the court has given you liberty to urge all these points at the appropriate stage. And these point which you are arguing may be correct point, and you are rightly arguing, no
Right.
doubt about it. But these things has to be argued at the time of framing up charges. In the cognizance stage, I can't look into the provision, whether case is made out or not, 161 statement, I can't read those things. That is the reason this court has given you that liberty. I am again giving you that liberty. You argue and come back.
Yes.
Okay, right on. Right on. Earlier the petitioner has approached this court for similar relief by filing CRLMC number 196 of 2022. The coordinate bench of this court, while disposing of the said CRLMC, passed the order. This order. Okay. Instead of approaching the court below and urging all the available points before the court below, he has repeated this present petition, making the similar prayer. When the same is pointed out, Learned Counsel for the petitioner seeks liberty to withdraw this present petition and urge all the points before the trial court at the appropriate stage. With this liberty, the petition is disposed. I'm not making any observation. And all these points, you have a good point, you go and argue. Yes.
I am just only challenging that cognizance order. That can only the law and court below what happened the law and court below taking cognizance on the said offences. Those offences are not made out against this petitioner. For that reason, I have not abused any public place. I have not.
Right.
That is
But
coming.
that is at the charge stage. You can tell the court, don't frame the charge. It's not made out.
Even though that is not the ingredients coming, not the ingredients of the
Again,
section
you are saying the same thing.
3 of IPS minutes.
Again, you are saying same thing.
Yes. Okay.
And when the court is going to frame charge, you say that this case is not made out because of this point. And the charges will be dropped. Will you follow? You won't argue that.
I will follow also. For that reason, I bring if my lordship will.
No, I gave that liberty to you.
Stay will that order my lordship there for that reason.
Then I'll stay, and the earlier also you got the stay, stall the trial for years together. Now again you want to ask for stay.
Notice will be served. Then
no.
Notice will be served. They will appear. They will. Thereafter, all things will be happen.
Go and argue.
No.
Yes. Next.
Notice is required for that. I am praying.
I've already passed the order. 65. Yes.
66.
Also.
Next week.
66.
Next week.
Is there any asking? Who you are asking?
I have been asked to appear, my lord, by name.
I think you want to.
Yes, sir.
You want time.
Yes.
Please take.
67.
Yes.
I challenge the order of a cognizance taken 29/6 of 23.
Combat mind.
Yes, see, OP2. Sorry. That will be true. Wait next week.
Yes, my lord.
Deliver.
My lord, may I one
Name,
thing?
huh?
128th, my lord, 2021.
Okay, the 28th interim order to continue.
Oblige.
71.
Yeah.
We have already filed requisite file consult case title. We filed consult OP number 2 and 3. In force of D of late.
See.
Not being implemented. As per noting, my lord.
Service is complete.
My lord, directed to add the opposite part number 2 and 3. Victim.
That is weird.
Again. I have filed the requisites, but the consolidated petition has to be filed, that cause title has to be filed. That in the course of the day.
Simply adjourned.
Well, simply.
Yes.
72.
Directly the office to comply, because I have to file the that cost title, consolidated cost title, and notice has to go. My order say notice has to go.
Mr. Chan, the consolidated petitioner seeks time to comply the order dated, earlier order dated. Last order for 17, earlier order dated 22/2/2024. He may do so within 1 week.
By tomorrow.
72.
Please, Lords. The noting is that consolidated cost title already filed. And the other part of the noting has to be ignored. Since I have filed already a consolidated cost title, there is no need to correct the earlier.
Okay, it's all right.
So order arises
what
out.
is this matter?
Order arises out of 138 proceeding, which ended with conviction and compensation in terms of section 357. That was challenged. The appellate court, while exercising its jurisdiction under section 389, while releasing on bail, who imposed a condition in terms with section 143A of the NI Act. This is a case which took place, or the cause of action, much prior to that insertion.
And 148 is also there.
143A, that 20%. The second aspect, in while exercising 389 power, the court is supposed to see also that 357, it has to be stayed. Had it been a 143A order, the question would have been, as your lordship says. So it is purely a appeal. The appeal normally, after hearing, the court can also.
What is the check amount?
Check amount is 8 lakh. 8 lakh.
You are directed to deposit 20%.
Yes, my lord. And 20% saying that it is 20% of the 357 compensation.
Oh, just forget it. Don't bring. You have issued check. You are convicted. The presumption of innocence also goes. Now you have to pay the money. That's all.
Presumption of innocence, rightly said.
Conviction.
But question is whether the imposition of section 357.
Don't bring this fantastic technicality into it. You have issued the check, got dishonored, convicted. 8 lakhs.
Convicted.
Why
I
don't you
have
pay?
a statutory right. I have a statutory right.
You keep on exercising statutory right.
No.
You pay the money.
Keep on not is not keep. My lord, in fact, this 357.
What is your defense in the main case?
Well, defense those because it's a German of the appeal.
Defense is to delay.
No, not delay. That is what I now I propose. What I propose now, subject to your lordship's appreciation, let this condition be waived and the appeal be directed to be heard within a stipulated period, so that no one will be prejudiced.
Where is the opposite side? Shall I send you to mediation and pay the money and finish it up?
Mediation of that district court. It is better.
Mediation, go to mediation and pay the money and finish it up.
My lord, that will be district mediation at Koraput.
Where is the opposite party number?
Both are belongs to Koraput, my lord. One is Koraput.
The finance people will be readily agreeing to take installment because ultimately they have to recover their money.
It's a my lord. I openly accept this mediation proposal.
Where is who is appearing for opposite party number? Just see.
In fact, I think
notice was not issued.
But that from notice from the mediation center or the appellate court can also be.
Let us see whether somebody is appearing or not.
Notice has been issued, but probably it has not been solved because of that Koraput and Kotak discrepancy.
That's the problem.
Notice.
Notice has to go, na?
In that pending criminal appeal, your lordship can also direct in that pending criminal appeal before the session court, also mediation. That will end one case here and one case there also.
1 minute. Where is that? Where is the impugn order?
Pardon, Mala?
Where is the impugn order?
Impugn order page 15.
Page 15, huh?
15.
On which part you are agreed of?
No, so far as impugned order, my lord. Pardon, my lord. Sorry, I couldn't talk. But it is page 9. There are
It is
two
seen
conditions.
that the land court below is convicted the petitioner and has sentenced him to undergo simple imprisonment for 1 year. Further, the convicted is directed to pay compensation of those loans through
Theta condition got
default
both the
payment of
condition lo.
compensation amount further undergo simple imprisonment for years. And further, over the conjunctive factor, the appellant throughout the trial reached on the default of adjournment from 389 benefit is given. Give. Accordingly, let the appellant so be released on bail and he shall deposit 20%.
That is not the German of 389. That is what. But anyway, as your lordship suggested,
20%, see, 20% now the amendment is already there.
It's there
to do.
It's there, but 143 application and its exercise, these are distinct from 389.
But now the provision is there, court can, without application also court can do it.
But
what is wrong in it?
No, there is no. But while granting 389, the court says I am granting.
What I'll do is I will stay it for a limited purpose till the mediation is over. Thereafter,
that is what
I'll stay the operation of this condition till the mediation takes place.
Yes, sir.
You go and participate in the mediation.
That may culminate two proceeding. That may culminate.
So therefore,
yes, sir.
Service is not affected.
Not affected.
That's the whole difficulty. So write down the because you have wasted 1, 2, 3, 4 hearing has taken place. It's not moving at all.
No.
The petitioner has been convicted for offense under section 138 NIA, and he has been sentenced to undergo
2 years.
2 years RI with a compensation of compensation with the direction to pay compensation of rupees 8 lakhs to
in terms of section
the opposite party number 2, opposite party, and a default sentence of what is the default sentence of 3 months.
3 months.
So the default sentence of 3 months. 3 months. The petitioner filed the appeal before the Sessions Court. Before the Sessions Court. The Learned Sessions Court, by order dated 9/6/2022, extended the concession under section 389 2 of CRPC, 389(3) of CRPC. However, the following conditions were imposed. Condition number A, page 9, theta condition 1 and 2, theta condition. Page 9, following condition. Also, the petitioner is precisely agreed by the first condition. Therefore, he is before this court. He is before this court. Mr. Das has urged before which Das submitted that the condition is not sustainable because this condition is imposed under section 3. What is that? Which section you are talking about? Is not imposed under section 143 A of NIA. Therefore, he submits that his appeal should have been heard and merit without insisting upon the deposit of 20% of the compensation amount. I'm of since the matter is pending since 2022. I'm of the considered view that instead of going into the technicalities involved in this matter, it would be appropriate that the parties should be relegated to the mediation of district mediation cell at Jaipur. District mediation cell at in the court of says in the Court of District and Sessions at Koraput at Jaipur, and explore the possibility of settlement. Explore the possibility of the settlement. Accordingly, the impugn order dated 9/6/2022 is kept in abeyance. Till the mediation, till the conclusion of mediation. Conclusion of mediation. The district and sessions court Koraput at Jaipur is directed to place the appeal before the mediation cell, district mediation cell, and seek an report from the seek any report. Till then, the impugn order dated 9/6/2022 passed by the Sessions Judge Koraput at Jaipur in Criminal Appeal 29/4/2022 is kept in abeyance. The matter is disposed of. Go and explore.
Yes, my lord.
You may pay. Yes. 73.
Madam, 73, madam, kindly next week, well, on behalf of Mr. Oppress Boyman.
Adjourned.
He is unwell.
Adjourned. 74.
74, I pray for a passover. The counsel for the petition is on another court, my lord.
Restoration.
Otherwise, also you would have been passed.
Restoration by aschi.
What restoration?
Non prosecution by dismiss ହେଇଥିଲା. It has come for restoration. Well,
Is it in my hand?
CRLMC, no, it was assigned to my Lord Justice Mahapatra, and he will not. He was the counsel. He will not hear it. That in view of the
Now the
Honorable Justice said,
Voting of TJC, now it is
restoration.
Let it be restored. What is the
You lost me. Restore it and let it come after for hearing.
Where is that dismissal before?
74 and
Where is that?
Where is that order?
Where is that order? Show me.
Lordship, I do not have the case record. Just a learned friend informed that is on another court.
Restore
it and hear it and merit. What is the big deal?
Your Lordship, same order may be passed. It can be restored.
Your Lordship may pass.
Just give the file. Give the file. You tell me the date when it was dismissed in default, so that I'll recall that order and restore it. Mr. Marana, can you just assist? Which is the date?
I'm going through.
It is not to be found. Where is the application?
Your Lordship, wide order dated 10/5/2023, it was dismissed, my lord.
The wide order dated 10/5/2023.
My lord.
23, the coordinate bench of this court dismissed the petition. Dismiss the present petition. Dismiss CRLMC without
CRLMC number 332 of 2021.
331.
2021.
332 and
332, my lord.
332 and 331.
333.
333 and 332. Do that matter. Dismiss for non-prosecution. Therefore, the petitioner has moved the present application. Taking into consideration the contention and averment made in the application, the order dated
10/5, my lord.
10/5 so and so is set aside, and the file is restored to its original file. The original file, and leaves the matter for final hearing on such and such day. I restore it. Argue on merit.
Much obliged, Lord.
Both the cases.
Huh?
Both the cases.
Restore.
75.
Compromise matter, my lord. Must be directed to both parties that appear. Not today, my lord, like taken up first week of April, my lord.
First week?
First week of April.
Why?
It's some...
You 498.
No, my lord. 363 and 666.
Oh. First week of April. Yes.
76.
26, my lord, after lunch, my lord.
Password?
Yes, my lord.
Okay.
77.
My lordship, item 77 on behalf of Mr. Mahanti, I'm praying for passover.
Passover. I'm appealing for the opposite, but let it come some other day.
No, my lordship, after lunch. Class.
After Passover, he will ask the same thing. What is it? But yes.
Some other day, lordship.
Some other day he said that he's not ready. Opening part.
Okay.
Adjournment. Yes.
78.
May I please, your lordship? This is a matter that the belated filing of the TDS, your lordship, and your lordship had sought for that. What is the amount of interest so that it could be paid and
Yes, Mr. Mohammed.
There will be delay. It's more than 12 months. On a delay period is more than 12 months.
He has paid the interest also.
I have to pay because the lordship on the last date of Mr. Mahapatra was appearing. Your lordship put that, okay, how much the interest I am ready to pay. Therefore, your lordship passed an order also. So,
How you have paid?
no, I have not paid because they have not given on the last 2 days. He was not available before your lordship.
First pay, then we will consider. They will also be lenient once they get.
No, that's right. I am your lordship. Therefore, your lordship said that how much the interest. That is the calculation.
He can't tell. You have to go to the concerned officer and calculate.
Actually, there is a 1.5%. There is in the statute itself the delay part.
And thereafter, I will impose some cost and quasi.
Yes, your lordship.
First pay and come.
I'll pay them. If you, my lord, if your lordship will not direct, then they will not accept.
No, I can't. I can't facilitate you for.
But otherwise, they will not receive my interest. That is the difficulty.
There is observation they see in the order.
That's
There
it.
is an observation. I've stated it also. There is a observation. There is a delay. Technical offense being
My lord.
alleged to have been committed by the petitioner filing return belatedly about a year's delay.
Yes, sir.
Matter is heard earlier and sought the appropriate time to seek instruction of this matter and argue at length. However, on the last date of hearing, nobody appeared on behalf of the opposite party until the Public Counsel, Mohammed Sending Counsel for Income Tax Department seeks adjournment. Okay. Mr. Divedi, Learned Counsel for the petitioner, seeks time to approach the concerned authority to pay the interest accrued due to non-payment of TDS amount deducted from the agents or
from the it's a salary that the employee salary.
And pay the interest on the belated deposit of TDS amount.
My lord.
TDS amount. Let the matter, release the matter on such. April record. You go and approach.
Yes, no, I tried.
Mr. Mahapatra also can't do anything. See, today what happens is the interest is not paid. I can't quash it.
No, that is why, because last 2-3 days you will also be hard.
Unless you complete everything.
Yes, I understand.
Then Mr. Mahapatra can be little lenient. So go and do it. If the authorities will not take the interest, then what to do?
He was not appearing on the last 2-3 rejections.
You try to appreciate his position.
I agreed for that.
Concede here.
I agreed, but actually they do not receive my interest also. That is the now they will. Yes, I think they will.
Then we will see what cost. Yes.
79.
May I permit it to place my lord on behalf of Mr. Patnaik? Item 79.
Yes.
My lord, here in this case, my lord, for quashing of proceeding on the ground that, my lord, the present petitioner purchased land from legal heirs of the Bhattakrishna Pradhan and had once again sold to land purchased by the company in different vendors. My lord, I am the one of the purchasers since 2017. The complainant alleged that I have purchased the land since 2000, my lord, and filed a GR case. That was final form was submitted. Thereafter, in protest petition, my name has been included in that. I have also filed an application under section 205 that has also been rejected by the learned court below. And in the meantime, other similarly situated one purchaser has been allowed by this honorable court filed
CRLMC number 4081 of 23 million wide judgment dated 21/11/23 million.
So,
While the present petition also stands on same footing, my lord, in
so
purchase.
where is that order?
And this, my lord, I am, lordship. And this order, I am also.
Copy ଦେବେ କୋଉ order ଟା? କଣ order କଣ ହେଇଛି ସେଥିରେ?
40
Nee, what is this order? The quest?
No, my lord, and allowed the 205 petition for that similar situated persons.
The lordship kindly have a glance on the prayer of the present petition. What is the prayer made by the petitioner here, your lordship? The suppressing the material fact, your lordship. Your lordship know the basis of the criminal prosecution is the FIR that has been ended with final form, but that FIR has not been annexed to the petition. And your lordship,
now what he says is, I have asked for quashing, but my application under 205 is rejected.
that is not the that is not the prayer of the petition before this.
That it what prayer?
No,
in
no,
case?
the
Kind of petitions are being filed. And
No,
you also filed like that.
No, so far this order is concerned, I have filed the recall application because yes, your lordship. Expiry order has been passed without issuing notice to the complainant. This order has been passed, your lordship.
Wait till that application is received. Then
And
you
the
get
present petition is not maintainable. Without challenging any order, prayer is to quash the proceeding.
My lord, I have
Without
also annexed page
annexed the
45.
order, Cognizance order is annexed,
Your
205 order is challenged, but prayer portion of lordship kindly see, there is no prayer so far the which order he is challenging here.
now he is saying that further proceeding in ICC case number now pending in the court. So on
Yes,
so forth.
further proceeding, the stages of proceeding your lordship knows. If he is trying to
Seeking
quash the
quashing of everything.
Yes.
that can't be a lordship without
Not
challenging the order of
See, not
Cognizance
happily
order.
worded. Forget about these are not the suits and all. These
Yes,
are
Lord.
criminal cases, not happily worded. But the fact remains is he has two grievances. One grievance is quash the entire proceeding. Second is a co-accused has got the benefit of 205.
That prayer is not there. That prayer is not there.
That's not there, but he is showing this judgment now.
That document.
You have
Yes.
challenged this order.
Yes,
Let
Lord.
us say wait out for outcome.
My lord.
205 will consider. Okay. Simply I am adjourning. Let us see.
My lord.
You get that if you are setting aside that order, that 205 is washed away. Then we will see.
My lord, civil suit is pending, my lord.
So
Yes,
that
cut-off
is
order is
there.
there, my lord.
On merit, that
And
is there.
this is a civil case, my lord. This should
But if
two-sided
Cognizance
challenge.
says why should this court will involve?
Yes,
Yeah,
Lord.
for that reason, I am praying in 482, your lordship can exercise in vast jurisdiction. I am praying for appear before that court in 205. and I
Challenge
will
that
also
order.
proceed
Challenge
matter.
that order. Challenge that order, filing appropriate application.
And similarly, my
In the
lord,
behalf, it is not
Now
maintainable.
he made you wiser. At least you do
Yes.
needful
Yes.
so that objection also goes. I am simply adjourning it. Whatever objection he has, take
Yes,
care
sir.
of his objection.
Okay.
Adjourn.
they can file.
Yes.
Item 80.
Pardon my lordship, item 77, there is a interim order.
Interim order will continue.
Yes.
Yes.
Item 80.
Item 80, after 2 weeks,
After?
after 2 weeks, my lord, an interim order continue.
You have an interim order, therefore you are.
No, I am ready. I'm sorry. It's a case, my lord.
I am for the opposite party. I am for the opposite party.
Yes.
I will file counter. I have not obtained some documents. Therefore,
It's a case where it requires an interference. Yes, well, my friend, I am ready. I am ready.
prior to this CRLMC,
4 applications has been filed.
4
There is
applications have
an
been filed.
interim order. I was thinking that I will hear it. And you are asking time, then.
Then it's a good point of law here decide how. That whether the concerned ballot because the check has been issued by a particular trust. So whether the trust without any measure case can be maintainable. Supreme Court also this one court in various decisions has been held that it is not maintainable. So on that ground it requires my friend is taking
Then
time.
counsel for the opposite party seeks time to file counter. Reach the matter on such day, interim order to continue.
Last week of
कौन है?
April ले कर दूं.
April.
Yes. Observe.
81.
This is a check amount. Why can't you go to mediation and finish up?
Let my friend file.
आपण असं shall I send it to mediation?
Let my friend file the counter thereafter.
Meanwhile, you can explore the possibility of settlements.
I mean, say you ଜିନିଷଟା ଗୋଟେ ଜିନିଷଟା ହଉଛି କଣ, that will be cause of the case. If things will come up in my favor, then something can be.
But it is a check amount. Technicality, in technicality, you have the
That is a
case.
ground. Technical.
But meanwhile, you explore the possibility. It doesn't happen. No problem.
Yes, ma'am. Madam.
Doesn't happen. Okay. Write down. इतना लिख दियो. Item ta? 80. I'll give little longer date. If possible, do it.
Yes, ma'am. Yes, ma'am.
Not possible.
Madam.
We will hear it. But this case is arising out of a complaint under 138 NI. Mr. Chand appears for the petitioner and raises a question of law regarding the maintainability of both the complaint itself. Although the notice was issued to the opposite party and the substantial question of law raised by Mr. Chand has been flagged to be decided by this court. However, in the interregnum, the parties may explore the possibility of the settlements. Therefore, the parties are directed to appear before the High Court Mediation cell.
They are fixing time.
On 11th of September, 11th of March 2024. 2024, so as to explore the possibility of settlement. Awaiting the mediation report. April. 10th April.
But instead of 11th, can it be 18th?
18th.
Aye.
11 तारीख को तीन हुआ पे निकला ना
much of it.
Explore
Entry mode continue.
Entry mode to continue.
I'm sorry, my lord. In 78, the intermode is to continue. 78.
78 entry mode. On the entry mode, water will continue. Don't worry.
My lord,
Unless I say otherwise.
My lord may kindly keep it.
Entry mode to continue.
In 78, your lords. Deeply.
81. 81. 82.
May I please?
Yes.
In connecting matter 4691 of 23, now I am filing the charge sheet copy as per the direction of this honorable court on last occasion. Madam, the case is like this.
Opposite party.
I am for the opposite.
Yes. Give a copy to him.
I am the wife, he is the husband, already divorced over.
Petition. So probably they'll be making a submission that day. They made a submission that day, and according,
I'll adjourn it next week.
your lordship may take it up in the usual call, because your lordship, the representatives are also here. We are on the question of 482 petition, which was filed challenging the summon issued to the director to appear. That your lordship has jurisdiction to decide, even if the criminal revision has been filed. Let it be taken up at 3 p.m.
That in that case, Mr. Pari is making some statement.
He's making a modified statement that they will not be protected if they appear. So if your lordship takes it up at 3 p.m, it will be much more clear.
Okay. That matter in any case.
Fourth revision matter, sir. Fourth revision matter, sir.
So I'll sit at 2:30 and 3 o'clock. I'll hear you. Because the revision password?
Password short of damage. I will reach up.
So at 2 o'clock I'll sit. Okay. 3 o'clock I'll be here.
Yes. Much obliged.
Adjournment, kindly taken up today, lordship.
It comes some other day. I don't have the mallet.
Sir, take the place.
We adjourn to which day?
9th April.
19th.
9th April.
9th April.
Item
In any case, he's asking for time.
Again. Let's say kindly taken up tomorrow.
Not tomorrow. Not at your sweet will. Somebody comes and asks for adjournment. Somebody
Yes,
mentions it.
It's
Not at your suite.
sorry, Lordship, he is misunderstood, Lordship.
What is the big deal of misunderstanding, whether it should be adjourned or argued? That what is the question of
Lordship, pass over କରିବା ପାଇଁ କହିଥିଲି ସେ adjourn କରିଦେଇଛନ୍ତି.
anyway, password you consider that as a password whenever it will.
Item 33.
Yes.
Madam, item 33. I was not there. That has been adjournment.
33.
I'm thinking that
It is 33.
The CD called for.
CD called for.
I was not there. I am thinking that
Anyway, CD called his appearance. Your appearance.
already charge sheet file 354 10 postcard.
The present petitioners are in custody from 8/8/2023, Your Lordships. There are a number of petitioners, Your Lordship. In the index, we have submitted the date of custody.
302.
Yes, Your Lordship.
CD called for. Yes.
Much obliged, Your Lordship.
24.
24, my lord. May I please your lordship? My lord, here the petitioner is in custody since 5/6/2023. An offense under section 20B Roman 2C of NDPS Act, my lord. In this case, my lord, investigation completed and charge sheet has been filed, which also reveals from the rejection order at paragraph 3, my lord.
What is the recovery?
Recovery is ganja, my lord, 80 kg ganja. My lord, the present petitioner.
PLA number 10619 of 2023 and 10620 of 2020.
That's not there with me. It has to go there.
No, that's pending. Both the applications
Pending, but 23 matters I can't hear. Only 24 matters I can.
But
then it has to go to
the present petition has no single criminal.
That's right, but there are two other co-accused persons.
Yes.
Matters are being heard by some other bench.
Yes. But that is pending also. Those two bail application is pending.
But it has to be considered by one judge only.
Yes, my lord. But
The two co-accused persons have filed separate petition seeking regular bail. Check regular bail. Both the petition being the number are pending before the coordinate bench.
Yes.
Let this matter be also listed along with those two matters. Yes.
25.
25 302
Subject to permission from the court.
25 302 CD might be.
302 CD.
Might.
Yes.
Yes.
26.
may I please?
399402 custody since 9th January 24. Co-accused statement, the petition have been implicated.
339
402 preparation for dokaiti, my lord.
You are
I am Satyajit Sahu alias Jotia.
26.
26.
861 of 2024. List
Tomorrow, my lord.
next week.
Seটা কখন কি?
Next week.
Co-accused র?
Next week, huh? Yes.
Day after tomorrow, lord.
Next week. Bail day is fixed Monday, Tuesday.
Monday.
Friday.
Friday টা holiday টা আছে।
This Friday, if you want to come, come, but I am not there.
No, Monday, your lordship, on 11th, my lord.
It's practically not possible. So many. Monday,
এটা
Tuesday.
খালি
Tuesday.
Monday আসু তাহলে।
Tuesday, let us see. Practically possible, then only it can be taken up.
12th, I may not be here, my lord. 11th তাহলে আসু।
Out a week per pocket. Out a week. Next. Yes.
33. 33.
You know, keep it to 15.
Already 354, 506 and 10 of the postcard.
354.
Getting the
That is the young lady is appearing. Let it be tomorrow.
Well, just now I'm getting.
Huh? Tomorrow. Don't worry. Tomorrow.
The file date is yes. Pass it.
Oh, pass it.
Yes.
Take glass. Wait. Yes.
47.
Yes.
47.
My lord, let's kindly see the last order. It is also non-appearance. Your lordship may issue notice to the petitioner. The bail matter, my lord, since he is in custody.
He is in custody.
Yes. But instead of, my lord, this is for deferred, lordship should, my lord.
Who is the lawyer?
It is being adjourned from time to time. One,
Kirtan
70
dance. That's a problem. On the last occasion, when the matter was taken up on 12/2/2024, nobody appeared. Even today, nobody appears. Even today, nobody appears. The issue court notice to
petitioner, to the jail through
returnable. What is the offense?
Well, it's a 376, 3 and 6 books along with 3 SCST.
April. Yes.
48.
May I please?
Yes.
My lord, final PR submitted on 22nd January 2024, my lord. Meantime, my lord, charge also framed, my lord, on 8th February 2024.
What is the offense?
Offense is, my lord, 21B of NDPS Act. 35 grams of brown sugar was seized from the
He is
petition.
having similar incident, 21.
Face it. Wait.
My lord.
Wait for some time. Charge has been framed. Wait for some time. Brown sugar, what to do?
Yes, ma'am.
I'll just dismiss it at this stage.
Yes,
and you repeat it.
Come at a later stage.
Kindly adjourn the case, my lord.
Why to keep it pending?
My lord,
You
after-
can repeat it before trial court if the trial doesn't proceed. Which district this is?
This is of my lord. District of Khordha district. Khordha district.
Khordha.
Yes, my lord.
Right on in the present case, the charge sheet has been filed and charges have already been framed. And the trial of the case has already started. At this stage, the present application is dismissed with liberty to the petitioner to revive the main application after 6 months.
After 6 months?
Yes, revive the application after 6 months, and it is expected that within this period, the trial court will do well to see that the
Not permitted to withdraw. Simple withdraw, my lord.
Simply withdraw.
Yes, ma'am. Obliged.
Yes. Next.
76.
My lord, 506 is there, 307 is there. Compromise petition filed, my lord, at Plaque C, my lord. And informant petitioner are present, no.
Sorry, I can't hear you. What is this? Here?
My lord, 507 is there and sorry,
307.
307 is there and compromise petition.
Show me the injury report.
Injury report. What's your details?
Yes, Mr. Praraj, have you seen it?
Yes, my lord. Injury is the, my lord, informant.
Simple. They have settled the dispute. Who are they? Let's see. Babula Jena,
Sit.
Daka Jena, Lipu Jena.
Lipuzena is absent. Lipuzena is absent. He is a student and suffering from fever. So,
And Sanjay Pradhan. Mr. Praraj just asked Sanjay Pradhan whether
Yes, sir.
The influence of what? Just ask. Sanjay Pradhan, come.
Informant.
Sí, sí, Xerox.
Affidavit.
Close neighbors, that's why, my lord.
Okay, right now, at the instance of opposite party number 2, who is the informant and the injured. Informant and injured in the case, the FIR number so was registered. The parties have settled their dispute. The petitioner number 1 and 2 and opposite party number 2 are present in the court and represented by their respective counsel and identified by them. They filed the self-edited copies also. The parties have settled. Parties have filed separate affidavit. What is that? Where is that affidavit?
Flexi.
Yes. The opposite party number 2 has filed an affidavit inter alia stating that he has settled the dispute with the petitioner under the intervention of the well-wishers and the village entries. He doesn't want to proceed against the petitioner. The petitioner have filed the certified copy of the charge sheet and the injury report, which is taken on record. The result of the injury report indicates that the injuries sustained by the opposite party number 2 are simple in nature. The Mr. Faraj appears for the state and submits that since the parties have settled their dispute amicably, all the petitioners and opposite party that belongs to a village, in order to maintain peace and tranquility in the area, the settlement has been entered into. Since the injuries are simple in nature, there is no legal impediment to passing the FIR. And pay, how much cost you will pay? You will pay cost. That 307. 3 of you is there. 1,000 each.
My lord?
1,000 each cost. And one of them is not appearing also.
Yes.
Cost 1,000 each. To the bar association. Yes.
Okay.
Revision.
86.
That 46 may, my lord, may kindly take, I got the CD, my lord.
The 46.
My lord.
Yes,
Right.
46. 46.
Lordship, it's a case of 394/34 IPC, Lordship. Allegation against present petitioner is
Read 164 if you have.
That 394, my lord.
390.
394.
Yes. Your lordship.
No.
Put condition, your lordship.
394.
Yes,
Lordship.
What are the allegations?
Allegation against 2 unknown person.
354, I thought. Yes.
Lordship.
Yes. I thought
When informant and her husband returning to her house, at that time 2 unknown person came and obstruct the informant, taken away cash of ₹80,000 and her money purse, Lordship. That is the allegation.
Present petitioner has been named in the affair. Petitioner along with some others, my lord, they have committed. And the present petitioner having, my lord, 6 criminal incidents.
6 criminal incidents.
Yes, your lords. Apart from this case.
Lordship, in the meantime, one of the co-accused person granted bail, that is, I have annexed.
Right, the petitioner is accused in FIR number 24. The allegation of the against the petitioner are that page 9 release itself. The counsel for the petitioner submits that the co-accused has already been granted bail, and he is in custody since
Lordship, 25/7/2023.
25/7/2020. Mr. Praharaj appear for the state and submits that the petitioner has petitioner is accused in as many years. How many cases?
6 cases.
6 cases. In view of his antecedent, stricter conditions should be imposed in the event the petitioner is released on bail. Taking into consideration the aforementioned facts, so bail 0, and he has to, the petitioner is to appear before the which IIC?
But it is Gonia police station.
Gonia police station.
No,
Gonia.
Gonia.
GANIA. Gonia PS. Nayagar.
Yes.
Gonia PS Nayagar. Every Sunday for 2 months, for 3 months.
Yes.
For 3 months. This is one of the conditions. Yes.
Okay.
Okay.
86. 86. Yes. Non-APS. Court notice. Court notice to counsel for the petitioner. 86. Yes. 87. 87.
The matter has been listed after 2011 for the first time. I seek some time to.
For the next, you.
The first week of April, man.
Then counsel for the petitioner 6 times. Yes. 88. Yes.
Charge was framed under section 406, 411 IPC.
Hmm.
The co-accused has been acquitted by the London Trial Court, from the whom alleged vehicle was seized. And the fact of the case is that the present petitioner being entrusted with a Bajaj scooter for repairing, he has sold the scooter to the
common judgment.
co-accused.
In the common judgment, the co-accused has been
Yes, no,
acquitted,
says one judgment.
but is convicted. You are convicted
Convicted me.
for offense under section
406 IPC. my lord.
406. Okay.
And the informant is PW3. He is not the owner of the vehicle. He has stated the vehicle belongs to his cousin, and he has given vehicle me for repairing. I sold the vehicle to the co-accused.
Hmm.
But the informant in the London court below has been turned hostile, did not support the prosecution case,
Hmm.
and his brothers are PW1, 2, 3 are his brothers. They have also stated the seizure of the vehicle from the co-accused is also not proved. And the vehicle was seized from the brother of the son.
Hmm.
So it is selling of the vehicle to the co-accused is not been proved by the prosecution.
Yes.
So
Take me to 313 statement.
it is not
You
with
have
me. my lord.
313.
Not with me, it's name with LCR. my lord. The statement is not with me.
LCR is there. LCR.
No. It's soft copy is there. Hard copy is there.
Soft copy is not here.
Soft copy is there.
86.
87.
LCR is there.
And the seizure witness PW,
Are you ready?
seizure witness PW 6 and 7 also taught hostile.
If he is ready, then I can hear it.
That is some other day.
Monday, Tuesday, we are hearing bail matter. Keep this Tuesday. If they are ready, everything is there. You can hear it. Tuesday?
Next week. 18th.
18th. 18th. Huh? 18th for finalist. 18th. Shall I record that it's partly heard? So that 18th you will not ask for adjournment. The matter is partly heard for further hearing on 18th. Get ready with 313 statement. Let us see what are the evidences which has come on record.
Evidences
Thereafter
are with
we'll
me,
see, huh?
but three charging statement is not with me. That is my obligation to share.
Yeah, that must be there. You to arrange it. Don't expect that the court will do everything for you.
Not
You have
that
to read it. 313, just see what are the evidence which has come on come against you. Thereafter we'll see.
Yes, yes, I will supply.
You supply the copy and be ready with 18. I'll finish up this matter. Yes. 89.
89.
Then comes for the petitioner seeks an adjournment to reconstruct the file. Please, the matter on 18th for
21st. No, that's it. 84.
90. 90 is there.
90 is
Okay, next time when the revision petitions are there, just put that no adjournments are being. It's not the formality that matters are listed and asked for it. Just indicate no adjournment in the revision petitions will be allowed. They all are 2011 petitions. Yes.
Whatever 84 and 85. 84 is regarding.
You indicate that, we'll see. Yes.
84 and 85 both are relating to that vessel.
Yes, yes.
So, last occasion, my learned senior for the.
Yes, 84 is what?
84 is regarding that summons to the.
Summon.
Direct.
Yes. That we can dispose of with recording your statement.
My lord, two things are there. There before my lord in two application. One is against someone, another is against the order. Against the order of the learned ADJ is concerned, we prefer to file a revision. Today it was listed on I mentioned before Justice S. Rath. I expressed that because this matter is pending with the court, so at 3 p.m. So Justice Rath assigned the matter to the Chief Justice that either that court will take the matter or I will take the matter. They decide by the Chief Justice the matter. And go and mention. Because my lord, I have to mention with the court because the specific date was fixed 3 p.m.
So then insofar as the 85 is concerned,
85 concerned, there is no issue because I segregate
well,
this.
simply adjourn it. We'll see what happens there.
So far
and come to 84 now. 84 is the only thing which has to be decided. Let us see.
May I just submit regarding 84, we rely on a series of judgments and the ministry guidelines to say that these summons are valid. Since a proposal came from the court that why don't you appear in VC, we agreed for that. Then a proposal was mooted by them that let them appear in person, we will not arrest them. Last occasion, my learned senior, I'm told by my colleagues that he withdrew that undertaking that he will not be arrested. So in view of these and we
no, he doesn't say that. You doesn't say that.
Last occasion he did make a mention.
Filing an affidavit explaining about this same issue on because the conduct of the petitioner is not come to that much of fairness for which now question of does arrest or does not go to the arrest is not decided just now because the immediately showed there is a direction for arrest. In the admitted suit,
Arrest of the
even though
vessel.
they are not made part of the custom department, an order was passed. Now we are going to implement as a of each party in this case. In every suit is party concerned. Now challenging the order of the release of the vessel is concerned, we are filing a revision application. Now only thing is left with my lord as you go to someone proceedings concerned where my lord is protected them and they are going now questioning whether we can allow to appear through BC. Or he can come on physical.
Why to complicate on the technical issue? You are in the investigation process.
Yes.
Let them come and participate. Find out you don't know what material has come on record.
Suppose
and
nothing
what
will come up, you will not arrest. Suppose nothing will come up from
the entire thing is the apprehension.
Apprehension, yes.
Apprehension.
Yes.
For apprehension, he will not come. So you make a statement so that let him come and.
My senior has now submitted, my lord may see. Our apprehension is this, that with each passing day.
You have a genuine apprehension.
now we have, because first day they said you appear through VC, we were agreeable. Second day they said that you appear in person, we will not arrest. Then third day they say that no, now we will arrest.
Because they are not coming with fairness.
This is, my lord,
Now
the sovereign,
step by step they are
it's
showing the
not a
conduct
private
so nice.
individual.
Show me
The
the
sovereign
affidavit.
country.
Show me the affidavit.
Yes.
Copy they are giving now. So my lord, let them
Who evident
go ahead with
must
this. If they want to take it legalistically, we also are prepared to take it. My lord, may give us some time, we'll respond to all this. If they are questioning our conduct, we will also file affidavits saying about their conduct, what they have been doing since we are almost completing 100 days here. And it is, my learned senior was fair enough to admit that we were the ones who triggered all this. And this is what we get in return. Time, my lords, is very essential.
Hey, what do you don't say anything in this affidavit? What do you say in this?
My lord,
What do you say in this affidavit?
in this affidavit said that the person concerned who has taken up the vessel very shortly, and he has to come and apprise the investigation. We have explained all these things. So whatever submission I made earlier occasion before 2 dates, what my learned friend is submitting with the court, then let them come. Will not appear. That question doesn't arise because in the court itself declared that he will arrest. So we cannot stick on this pen. We can't arrest. You cannot go on the conduct.
It's not a question of can't arrest.
Number two, suppose he'll come and appear to the investigating agency. Found that is not, you see, my lord, the conduct of the investigating agency. If we have an intention to harass or anybody or arrest, the first day we are getting information, we can arrest, start arrest. We are interrogating everybody through officials, everybody. And we want to know what is the source, where it is coming. The possession it was kept. It is not.
Do you have any material against the?
Yes, yes. That is the.
Why you have not put it here? These are the material.
It is under because in the process of investigation. If lordship want, we can see produce the seal cover. No issue. But it cannot be opened because in the process of investigation, many things will come. Many things will come.
That's right, but that is the reason. Think over one thing. I will protect them for some time. They'll come and appear and cooperate with the investigation. Think over it, because the investigation has to proceed further.
Yes, then
Not that you can't stall it, thinking they will be apprehending. They will resort to many proceedings. As a result of which your investigation is stalled.
No, my lord. Investigation is stalled because of non-cooperation.
So see, then it's a tug of war kind of situation.
Yes.
Tug of war kind of situation. Better course would be protect for some time, let them come forward, and investigation should proceed. If any material comes, then that protection is limited protection. Thereafter, you can take whatever action.
Then my lord, I want to do one thing. My lord, keep it the affidavit in the record. Please keep it the record.
Take the affidavit on record.
And
we'll file the response to that.
Let's keep it to Monday or Tuesday. Within 2-3 days, I will come with a proper instruction because first Friday.
See, the proposition is what my thought process. It is I'm thinking louder. I can protect them for some time so that fearlessly they will come and participate in the investigation. And if some material comes, then they'll face the consequence.
May I submit my?
That part I will take instruction.
As a result, now what is happening? Everything is
not
solved.
coming. We are also not doing it.
May I suggest, my lords?
Nothing is happening.
May I suggest? Our entire crew, 21 crew members at their disposal since day one, 90 days, and we are counting. This is vis-a-vis only the MD, nobody else. He was admittedly in Vietnam when all this happened. Ship has come from Indonesia. It has not come from Vietnam. Now, initially when it was all informal just to cooperate, because otherwise they have to follow the procedure.
You are unnecessary apprehending because it may so happen that nothing can come against you.
My lord,
you are now the apprehension which you have. That apprehension I'll take care of.
That apprehension we will allow and appear, and we may be allowed to leave the country thereafter. If that they are agreeable, then we are willing to appear in person. Because earlier,
I can only protect you that no coercive action against you. You come and appear and cooperate with the investigation.
No, then
for certain time I will give. Within that time you come, go, I don't know.
Then my lords, the
What do you
letter
do?
rogatories which are there, then they have to approach the foreign courts and then get it done through. That's the law. They have to follow the law. Then I'll have to press my case on merits. In merits, I'm protected by Sunil Bharti Mittal and their own circulars, central government circulars. For a foreign national, they have to follow that procedure. My lord knows a series of judgments. You follow the procedure, otherwise not at all. So then I'll press my case on merits legally, my lord.
Then what will happen is technically keep on fighting for years together, nothing, you are not moving further.
Technically, the central government knows that if they go after this person, they have to pursue me for years. That country has to
No, absolutely like that.
Then everything is solved.
It is not.
Everything is solved.
Then my lord,
Government
we are
is
willing
not
to cooperate.
helpless.
My lord, these kind of guarantees which they give and then withdraw.
And you must also appreciate your crew members are there.
Yes.
And
we are willing
you
we
have
are
come to their
cooperating.
rescue also. Not that at their cost you can't have an ego issue, I'll not come.
No, it's not an ego issue, my lord. It's not. My lord,
I will protect you, I'm saying you.
My lord, that protection, my lord, this now every passing day they are trying to.
So therefore,
take away the
it's more of a reason that you should come and cooperate.
That is also, my lords, it cuts both ways. That is also the reason why we are now apprehensive. First day they said that you appear through VC.
Apprehensive is genuine. I say that.
My lords, but VC we
Now
agree.
question is coming
Now,
in spite of my
just let me complete. Just let
They are not ready to come.
Why protection means at least the investigation will start moving.
My lords, let me submit, my lords. Kindly allow me to submit.
Yes.
First day they wanted VC. We took instructions. We are agreeable for VC. Second day, when we agreed for VC,
no, you didn't agree straight away. That's the otherwise I would have.
We are bound by foreign nationals. We have to take instructions. These are not locals, my lords. And as a
you made them wiser by taking time.
My lords, I bow down.
That time I would have passed this order and you would have by now investigation would have gone.
In fact, the Delhi CM, he is praying for appearing through VC. This is a law which is emerging. Now as matters move, then my lords, when we agree.
It was declined also.
When the matter move.
That is the part of the news. He asked for VC staying in Delhi, the investigating agency in Delhi. He asked for VC and it was declined.
Well, he is an Indian national. I can say, well, he is an Indian national. We are guided by the Ministry of Home Affairs, their own guidelines, which say that for a foreign national, they have to go get permission from the Vietnamese courts and then get it. Those are all a matter of record. We have filed it. It's not that I'm submitting beyond the record. When we agreed for VC, then they say that no, you appear in person, you will not be arrested. Then when my clients agreed for that, today they are saying, no, you get a limited protection. Thereafter, the materials will decide whether you will. So this kind of pulling the rug from under our feet in this nature, and look, this makes us extremely apprehensive. Any reasonable man would be apprehensive under these circumstances.
I say that the apprehensions are well founded. There is no doubt about it. But if this tussle goes on, take it from me, for years and years, your vessel will be here in the shore and your crew members will be detained. So it will not move further.
We have faith in the system of this country. The law laid down is so far as release of vessel, no questions asked, that is to be released. Those series of judgments we have given in the next matter. So far as letter rogatories, the law is very clear. Now, if the central government councils, they will say that we will not abide by our own circulars, our own laws, then I have nothing to say. Their own. Now, so far as our crew members, they are waiting 90 days, they are there at their disposal. They have not entered the ship thereafter. They want investigation. The entire crew is there before them.
They want to know the source.
The master
from
of the
the right at the top man, they want to ask.
These materials are
Can you stop asking investigation?
Let them follow the law.
We don't know. We don't know in which angle the investigation is put.
Then they have to follow the law which the Ministry of Home Affairs has come with.
My lord, and this proposition you don't agree to that proposition.
I have made myself very
then
clear.
I'll have to hear it and decide.
We have made ourselves very clear. Each passing day, the conditions are being just enhanced. Last occasion when it fell from the court that no, you appear in person, you will be protected, you will be allowed to leave. That instructions now we have that yes, we are agreeable to that. Today, my lords, they change their colors and say that no. You will only be protected till a certain time. Thereafter, each time come against you, we will arrest you. This is what has fallen from.
No, that has not fallen. That has fallen from the court. They have not agreed. He said that he'll seek instruction to that also.
No, but then that is not agreeable to us. If you will come, if we'll come from
Then
a
it
foreign
needs
country,
to be heard.
then my lord,
And
may
you
hear it.
respond, I'll fix it, hear it,
Then let
whether
the
I should
ministry-
interfere or not, I'll see.
Let the ministry's own guidelines be thrown to the wind and let them do
No.
whatever they want.
Their part, they will act, our part will act. Whether what guideline is accepted by us, what extent we will investigate, and what is the ratio basing on which we will investigate. We'll take care in this regard. My non-friends should not bother for this. Only thing I am saying before my lord, for establishing their bona fideness, you see in ship about 70 feet above, it was recovered. Without the knowledge of any persons and without knowledge of the crew or anybody, it was kept in a 70 feet above. If I come with a photograph, lordship also brings strength. How it will kept in that case? Only thing.
What was the provocation for
So
them to
provocation.
inform
There must be a
their own
planningly
to
set
you?
up in this transaction, planningly set up, basing on which they are regularly doing so, for which the investigation is going very seriously. They are took up the matter very seriously. Only arresting is not an issue. Issue is that what is the source, where they are getting up to that level. Security persons, then captain level, then crew level, then it is gone to the machinery top of the sales. So it is not a matter of issue. So
Anyway,
definitely, yes, it is not an issue that they are now arrest seizure some materials. It will be conjointly they are doing the practice which was come to knowledge of somebody else or whatever source may be. This captain is intimate and we have seized the materials. Now we want to show who is the owner, how it is coming, when it was occupied by them. Now they are getting my investigation. What they have orally told me that if recently one ownership transfer has been made. I don't think he is the particular same owner or something.
1 year back.
But now they are saying that before few months, 4-5 months like this.
You purchase it 1 year back.
So may I pray, my lord friend may file an affidavit as regard to their when ownership has come, which place the ship is coming, what concern was given. Then it is also a help to this investigation.
These are the questions you are supposed to ask the witness.
Oh, yes, that's why you asked this. It's come and
I suggest
interrogate this.
my lord may keep this pending. As a first brush, let them examine my clients on BC. If they are not satisfied,
that's the idea.
Yes, we are willing, as whatever has fallen from the court, we are bowed down.
Mr. Paddy, why can't we do that?
My lord may keep
one second.
To begin with, you examine these queries which you have, preliminary queries which you have. You can put to them through BC also.
No, my lord, the investigation part is called NDPS. It is a commercial vessel. There is a lot of restrictions are there. In commercial vessels, there is a lot of restrictions are there. And it is a case of NDPS and the customs department who is investigating the case.
No, in the preliminary, you need to.
Yes. Unless until this owner
give interrogatories, then.
Yes, interrogation is not there. It is not that one interrogation will be sufficient. It may become another interrogation. So with what they are apprehending, it is definitely outside pen. Definitely apprehend that if you will come, I will wear it. Definitely, it is obvious.
Submitting is backed by Supreme Court judgments where this VC examinations are permissible. It is not that I'm submitting something new.
My lord, they are coming against this someone who is issued by us.
I'm submitting that my lord may keep this 482 pending. As a first brush, let them examine. If they say that no, we are not satisfied, then we'll come down. Whatever we have agreed, we will abide by that.
This is an ideal suggestion.
May I pray, my lord?
Yes.
Today is the.
I'll keep. See, the proposition is I'll keep the 482 pending.
Yes.
And as a preliminary kind of interrogation, inquiry, whatever you say, you do it in the VC. If any material comes, then I'll decide it.
But VC is not permissible.
No.
VC is not permissible.
Say some judgment.
No, yes, might have cited some judgment. There is a judgment.
Some
over and the statutes provide.
G20 meeting is happening in VC.
Maybe, but not for the accused. That is a big thing. Not the negative
and
way.
Israel wants
who can use that facility for the accused also. So my lord may keep it to 12th or 13th.
I believe he's not an accused so far. He's a witness.
My lord, yes.
He may be an accused.
That's why, my lord, what I'm praying, lords may keep you 12 or 13, whatever convenient to me.
Okay.
I'm also.
In the meanwhile, two things will decide. One, the assignment of my chief
Give
justice.
that judgment to him. It may be helpful also.
Whatever copies their file, let them
is
give
something-
also examine the same.
It is not something which I'm submitting beyond the law.
Whatever judgments,
And these days, my lords, trials are being conducted through VC.
That's the
Trials, if trials, courts can conduct trials through VC, I'm just submitting as a first brush. It is not that I'm.
It is just
before 2 days,
no, this is the interesting. This is Variava's judgment. That time 2003.
Yes.
There was nothing like the
COVID
and everything. That time this was the
My lord,
contextualized.
before three
Today we
before
have
3 days, I appear before Justice Mukta Gupta in a arbitration matter. Madam told me, are you prepared to come here or I'll extend the time for vocal? Don't caution the witness on VC.
Then if you
Come
don't
in and-
concede his request, then you will also be not permitted to appear in it
Yes.
as a lawyer.
So,
Consider it
my-
and let us.
Ma'am, I will examine the same.
Let
Let me
us
keep to 12.
proceed.
I am not taking more time on 12th or 13th, whatever convenient to my lordship.
Let us make it on 14th. Huh?
Yes.
14th.
My lord. Okay.
And see, let the investigation.
I got the point, my lordship.
should start
Yes, I
moving.
respect. Yes.
Ah.
My lord is try to
If
find
you
out something by which
technicality we will reach
Yes,
nowhere.
yes. War. Yes.
They are also stuck. You are
My
also
lord,
stuck.
fine. Definite.
So let us start.
Start. Yes.
May I request for 13th? 14th, I have a outstation. 13th.
13th is 13th, no problem. 13th, Mr. Padi is also saying 13th.
Yes.
13th,
Let's be. Interim order to continue.
Interim order to continue.
It is better to 3 o'clock, my lord. Better 3 o'clock.
3 o'clock.
Yes.
Please number the I.
I will file before him.
We are all grateful. The second
And just
matter-
examine this judgment also.
Huh.
The judgment, Justice Variava's judgment.
Yes. I got it. I kept it.
And the second matter, my lord, may not pass any orders.
No, I am not simply adjourning. Awaiting.
Yes, this year.
No, go to that court, then
Yes.
that court will do. If it comes here, then.
That court pressed me that it is not, once you express before me that it is, hearing is going on, it is not proper to enter into this. Well, then I leave to the court. Then he is
There also I have got, knowing my senior members, I have got judgments for him. Pepsi Food says that we can file either revision 482 writ.
That you can file.
Yes.
The scope
But
of
since
482 is very larger.
since
We
now
are
he has
technically very
needed to file a revision, let it be.
So it's larger for us and for him also. I don't know. We are
But my idea is not to get the things stuck, let us move forward.
No, even we
Because
want
you
to
are
cooperate.
facing loss and their investigation is not moving an inch.
Let me
Because
make
of
that
your,
for the
non-cooperation.
record, my lord, let me make it clear. Right from day one, we were the ones who intimated that he acknowledges. We are willing to cooperate. But this, if they keep on changing the goalposts in this manner, we become apprehensive. I mean, and it is natural for anybody to be
Initially, from filing application is apprehensive because on the someone is he challenges and that means he apprehensive. Not by
based on the
sending
law of
people,
the
they're
country. It's based
So-
on the law of the country, my lord.
More
Well,
successful, more established people in the society are more insecure people.
Yes.
And that is the reason they face more problems. And
Always.
he had it been a common crew member and all, he would have come and appeared.
Yes.
And by now he would have gone out. Because he is a big shot, he has all kind of
Always. It is happening always.
It's not.
all kind of apprehension. And the lawyers feed in their brain that
No, man,
you may be
not that.
arrested. and
Let's-
all. Not you, I'm not saying that.
Maharaj, we are a shipping company of 100 ships.
That is the whole difficulty.
If we start appearing for each ship, then my lord, our
But this
business-
is a criminal case of, see the magnitude.
My lord, we
And you are in the trouble today. Your vessel is
what
arrested.
fell from the court, my lord, had we agreed on day one without taking much time through VC,
I think it
they
would
had
have-
agreed.
yes.
They had agreed. We had agreed.
According
it
to
would have been over.
the will of a witness, the investigation going on, it's not expectable, my lord. Sometimes the investigating agency is thinking something seriously, which may not be reflected to the other side also.
We may not know what is
We may not
going
know,
on
yes.
in the
The technicalities of investigation, what are their
they are
yes.
they are adamant to bring this gentleman because some material might have come. We know who knows.
Yes.
I must also state
That may not be disclosed to him also.
They are also not disclosing. He was saying something is there.
Language is also coming in. They are not understanding their language. These people, some of these 21 crew members, language is an issue. There may, from
They have
also
expert in customs department.
These are our apprehensions.
They have interpreted.
In custom department, all systems are there. It is for Odisha, it is one case.
Think over this proposition and come. 14th we will start proceeding. 13th.
Obligement.
They are all great.
I am passing this slip with both the counsels appearing with me.
Yes,
Mr. Bhutta and Mr.
Please do.
Yes.
And
Uti
when
Jana.
senior counsel name is there, the assistant counsel name must be there. Don't write only senior counsel. Senior counsel can't appear without instructing it. Yes. Finish. Okay. Thank you.